My lord, may I be permitted to mention? I'm for the appellant. It was from 7th July, but not in server till now, my lord.
My lord, I want to mention in my case number 8904 of 2022. I am a contractual employee of the West Bengal Concert Board. And I take NOC from my
What do you want?
proceed my case myself.
Your Lordship, may I be permitted to mention one matter for correction? Item, Your Lordship, item number 13 and 14.
May I have your lordship's leave to mention two matters for listing as application, my lord?
My lord,
Great.
to mention application for inclusion.
Lordships, may I permit to mention one correction, Lordship? Lordship's 2 point is third person's age is 55 years. And Lordships also consortium is not considered. Your Lordship's already heard, but till date is not Lordships. I have already given to the court officer. Also kindly কোথায় রেকর্ড আছে বার করে এই ধরনের মেনশনিং গুলো আমার শুনতে
Permitted to motor accident claims matter for inclusion.
Amit Ranjan Roy is appearing. In this matter, my lord, can 1 and 2 has already been disposed of by Honorable Justice Shubhendu Samanta when he was having determination, my lord. My lord will kindly see. And can 3 is my application for appropriate order, my lord. I have deposited, there was a delayed deposit on my part. I'm praying for the stay to be absolute and acceptance of the.
Have you given the challan?
The challan is in my application, can 3, my lord. My lord will kindly see.
Which application?
Can 3.
No. Monica.
6-7 হচ্ছে।
Hey, Aditya.
Can we give this? Can 3 is. I'll give the challan in course.
The application is there, not the challan.
May I come back at 2 o'clock? May I come back at 2 o'clock? My
Come
lord.
at 2 p.m. because the copy of the
My lord.
challan is not there.
I'll give this. My at 2 o'clock.
Next.
But this appeal has come at my instance for corrections of the lordship order this right under typographical mistakes. Your lordship kindly see on 10th June 2025, your lordship was pleased to dispose of the appeal.
What are the corrections to be made?
But the first page, this is the injury case. With court, Amyo Kumar Mollik and another should be deleted. Secondly, my lord, page 3. Page 3, calculation portion. My lord, 40% future profit, it should be 10%.
Calculation is correct.
10%, 12,000 is written. This will be.
Calculation is correct.
No, And my lord, your lordship kindly multiply 11, it comes, my lord, to 12,34,000. My lord, it will be 00200. 200 adding.
10 will not be there.
30 instead of 30.
Anything else?
And my lord, your lordship kindly see paragraph 9. My lord, there is a three case respondents claimants S should be deleted.
Yes.
And paragraph 11. My lord, 6 times.
S will be deleted.
Yes, my lord, that is suffice.
Today, when the matters for reference will be called up, you will be there. For the last 2 days, you left.
My lord,
You
after 4:30, my lord, my health does not permit.
so you ask your son to be there. If your health doesn't permit,
All right.
for your health, these matters cannot be prolonged. After 4:30, health doesn't permit. And if your matters were there in the list for orders, then your health permit.
Lordship, Mr. Singh is appearing in this matter. He is engaged before court 4. Kindly grant a short passover.
For the respondents. Number 20.
Huh? হ্যাঁ এরাই ভুল নম্বর দিয়েছে Respondent claimant
I
My
can
lord, I am for the respondents.
is present.
Filing paper book today, my lord.
Paper book filed by the learned advocate representing the respondent claimants
Date
we
one.
kept on record. Next date we fixed on 21st of November. Next.
And no cause of this. Date, please. My lord, date. What is the next date, my lord?
21st of November.
21st September.
November.
The petitioner in this matter.
Then 14, my lord, I am for the respondent.
The very short point in this matter is that my lord, denial of the promotion to the petition and my lord, the upgraded pay. I think the Food Corporation of India, that is the engineer is upon engineer. The engineers are professional ability. So they remain stagnant for the contract 30 to 25 years. So they have filed an application before the honorable that they should be given the function, or if not the function, the minor the at least the SCP. At least in the period at least two functional opportunities should be given. If not, the benefit and should benefit of that two promotional should be given. This honorable court, the learned singleton allowed the division bench allowed the and the honorable Supreme Court right of the petitioner by saying yes, you have to frame a scheme in such a manner so that the engineers of the Food Corporation of India should get at least two functional benefits if there is an functional opportunity. That should be given to them in their life pay. And whether that their appeal was dismissed with 50,000 rupees. Under this background, what they have done, they have framed scheme in such a manner, giving the retrospective effect from the after 24 order, they have framed a scheme. Persons who are already there, they will get the benefit. Persons who have done the job of 20, persons who have filed the petition, they will not get. So challenging this rate of implementation of that scheme, this is the in this petition, very short point is that ultimately the person, petitioner number 328, they got, because they remain in the service, so they got two promotional scheme which they have produced before this honorable by filing a supplementary. But admittedly, the petitioner number 1 and 2, who have never get anything, any benefits, the prospective date of that scheme.
When was the Supreme Court order passed?
And the Supreme Court order passed, my lord, in, I'm telling lord, at page 56 of that, my lord, it is at 2007. Date of judgment is 5th February 2007.
Page?
Page 58 of the writ petition. So may I place the order?
I'm going through it. You come to page 59.
Lordship.
During pendency of the said writ petition, a scheme was framed for promotion to selection grade.
My lord, it is a, my lord, when the single writ petition was pending before the learned single bench. Then what they have done, they have introduced the selection grade for the all the persons. And the selection grade, my lord, the benefited by the union as they employ the other. It is already written. So that is a, they are considering this selection grade also. The single bench observed that this selection grade is not the benefits which the petitioner sought for. So, my lord, the selection, this is negated by the honorable single bench, and up to the Supreme Court, it is told that this selection grade cannot be the substitute of the two promotional. And it was given to all employees, not to me.
To come to page 64.
Lordship. Lordship.
Admittedly, a direction was issued by the Andhra Pradesh High Court to the appellant for framing.
When our petition was pending, my lord, we have given an example before the court that for engineers you are not doing anything, but for the medical person, the Food Corporation of India frame a scheme so that, my lord, they can get to promotion. The medical officer, doctors. So, my lord, we have relied on that. So the court is, my lord, recording that.
So there was no further direction for preparation of a scheme. In page 65, 23, so far as the introduction of grant of selection grade is concerned, the same does not provide for a promotional scheme. It is available to a limited number of employees. By reason thereof, a promotional scheme cannot be said to have been framed. The scheme of accelerated career progression is distinct and different from grant of selection grade. We have noticed herein before that although such a provision has been made for the unionized employees, but even then they are also entitled to grant of selection grade as well. So for the reason aforementioned, there is no merit in this appeal.
Because the division bench order directed to help the scheme. From that they have filed the appeal. The appeal was, I am showing the page 41. 41, and we even the landed single judge at the Justice Bhaskar Bhattacharya at that point of time also directed. Kindly come to page 31st. Then your lordship with the single bench order. Page 30, 11, page 29. Page 29 it is started. Now if your lordship come to page 37. Lordship is at page 37. Lordship. In the fact and circumstances, I am therefore of the view that the selection grade introduced by the respondent authority is not sufficient to alleviate the grievance of the petitioner, and as such, I direct the respondent's authority to formulate a scheme similar in the nature. Here is the direction, and it is continued up to the division bench. Scheme similar in the nature which is applicable to the doctors of the FCI, so that the assistant managers of the engineering cadres to which the petitioners belong may get opportunity to get promotion at least twice in their service period of 24 to 30 years. The respondent authority are directed to formulate such a scheme within a 3 months from the date.
Now you show me the scheme.
Lordship, kindly come to page 82, Lordship.
Now, this order was of 27th of March 2003 for framing the
Yes, Lordship.
scheme.
Yes. Thereafter, my lord,
Where is the scheme?
That is at page 82. My lord, would your lordship please to see the division bench order? That's 41, Lordship.
41.
Division bench order. Started from 47, my lord. You can come to page 55, my lord, after discussing everything. My lord, in the middle portion.
Now, some of the writ petitioners, respondents got the benefit during the pendency of the proceedings, whereas the others could not. They were working since the very first day of their appointment in a post where they are stagnating. There is no reason why the principles so laid down in the case of Council of Scientific and Industrial Research and another be not applied in the instant case. Similarly, the plea that the central government rejected the proposal for introduction of SAP schemes for the unionized employees also not of any consequence in the instant case. The central government considered the case of those unionized employees and ultimately came to a finding that such scheme was not necessary for being introduced for those employees as there were promotional avenues. In the instant case, it is an admitted fact that the engineers working as assistant managers were having hardly any scope for promotion and they were stagnating in the same post for years together. Hence, such rejection of the central government cannot be a plea to avoid the introduction of
SAP scheme for the assistant manager. So this is the finding of the division bench. Now, my lord, the scheme is at page 82.
Directed same treatment to be given to the engineers working as assistant managers. Okay. Yes.
My lord, the page 82, madam. In compliance of the order dated 27th March 2003 in the writ petition.
May I interject, my lord? 80, page number 82 is not the scheme, my lord. It is not the scheme.
So what is the?
Which
All scheme is there, my lord. Let my senior friend finishes the argument. I'll place my submission. But that
82
is
is
not the
not.
scheme, my lord. That is a promotional order, my lord.
Because according to me, my lord, this is the my lord notification of the scheme. In compliance of the order dated 27th March 2023 in writ petition number such and such, my lord, in the matter of Purushottam Das Bansal and other FCI as upheld by the Honorable Division Bench of the High Court by order dated such and the Honorable Supreme Court dated such, the Board of Directors in its meeting held on 12th March 2008 and Government of India Ministry of Consumer Affairs, Food and Public Distribution, the PII Division by sanction dated such a has revised the sanction strength of AGM engineers as per proposed scheme. The entire promotional panel to the post of AGM engineers have been reviewed and redrawn with effect from 27 July 2003. Consequent upon review and redrawn panels of the following managers.
This is not the scheme. They have followed the scheme.
And the scheme method at the writ petition.
Have you annexed the scheme in your office?
My lord, what happened, my lord, during in course of the hearing, my lord, I took a specific point because, my lord, if my lord kindly sees the prayer of the writ petition and the submission made by the writ petition, there is a, my lord, the gulf of difference, my lord. So therefore, my lord, I raised a plea, my lord, the scheme has never been challenged and scheme is to be sanctioned by the ministry, my lord. We are one of the aegis of the Ministry of, my lord, Consumer Affairs and Food and Distribution. So therefore, my lord, we propose a scheme and that is to be sanctioned by the ministry. Ministry has not been a party. And once, my lord, the scheme is approved, whether, my lord, in its original form or in an amended manner, my lord, unless and until ministry is to be made a party and scheme is to be challenged, my lord, they cannot, my lord, put a question to me whether, my lord, we have followed the scheme in the line of the order passed by the, my lord, honorable single bench of this honorable court, my lord. What it is our specific submission, my lord, the scheme was framed in terms of the order, my lord, and that scheme has been, my lord, sanctioned in an amended form by the ministry. Thereafter, again, my lord, a sanction, rather a amended, my lord, scheme was proposed. That was also sanctioned. And from time to time, my lord, sanction strength of the engineering cadre has been increased. Though not in the proposed manner that we actually, my lord, put the proposal, but it has been increased. So in terms of the scheme, my lord, we have been following up. It is nobody's case.
According to him, it should have been retrospective.
Retrospective effect has been given, my lord. It is there, my lord. I can show. Retrospective effect from the date when the, my lord, the date of the judgment passed by this honorable court, way back in the month of March 2023, 2003, my lord. So the 3 months time was given to us. So therefore, retrospective date of effect was given in the month of June 2003. And the scheme was, my lord, sanctioned in the year 2008 or 9. So notional promotion has been given to the all the employees, including writ petitioner, my lord. In my turn, my lord, I'll place those submissions. But as long as, my lord, subject to correction, my lord, as long as the scheme has not been challenged, my lord, in my understanding, they cannot question the, my lord, the compliance of the scheme.
Question is not that, but he is saying.
Kindly see the prayer, my lord, there.
I am showing the prayer. My lord, the honorable court directed that promotion should be paid by the persons, the writ petitioner. 2003, which they are showing, that is the order of Honorable Justice Bhaskar Bhattacharya. But before that, my lord, the persons are working for 24 to 30 years. Before that, the persons, the writ petitioners were, my lord, rendering their services from 24 to 30 years. What they have done, they have put the effect of the scheme from 2003. The persons who retired, my lord, they have not given any benefit. And my lord, in the affidavit, they are saying we have given petitioner number 3 to 8. I am accepting that. But what about the 1 and 2? If they can show they have given the 1 and 2, the benefit, my lord, the matter will be disposed of.
What had been the benefit granted in favor of the others?
6 to 8 got in their service career 2 promotion, 3 to 8. But 1 and 2 have never get any. Now the scope of the deed petition is only up to the 1 and 2. Let them show what they have given.
What kind of promotion was given to them from selection grade, ACP, both?
No, ACP, my lord, as per the norms of the central government, they will get. Promotional benefit they are not given. The promotional benefit to promotion they are entitled, and when
The ones who have already received it, what kind of promotion? So the other two have received? I'm asking what kind of promotion did they receive? You are seeking parity, right?
3 to 8 may not get the 2 promotions in their service on the basis of the financial benefit.
On the basis of the, where have you mentioned that?
The reply of the supplementary benefit, I have stated so. I have admitted that.
Which paragraph?
And paragraph 6, Lordship.
Yes.
Reference to paragraph 9 of the supplementary affidavit, I deny. My lord, thereafter, I say that the petitioner number 1 and 2 served more than 25 years of service and thus entitled to
Aditya?
get more than 2 promotions in their career.
Flag
But
done.
was introduced in the year 2001 for all the employees and workmen of the FCI. First, they attempted to interpret that said selection grade was the substitute of the said promotional benefits for the engineer, but same was discarded during the final hearing of the deed petition. It is denied that the stagnant increment in the grade of assistant manager can substituting the promotional benefits of the petitioner. Your lordship come to page 43 of their supplementary evidence. They have made a table, a chart. Right, it was shown.
Which page?
43.
Yes. Yes, 43.
Yes, in 43. Under dynasty, picture number, details of the promotion, only one promotion.
Petitioner number?
Sorry, picture number 1. PD consult.
Yes.
Ticket on. They are showing detail of promotion, one promotion. And that's promotion.
Now, what about the other column? Details of benefit of stagnation increments, first on such and such, second on such and such. As you said, they had received financial benefit, right?
It is the increment. They showing increment.
Why would they receive increment after a gap of 8 years?
As per the pay scale, they will get the.
So the increment, if it is logically construed, occurs every year. But then why were they granted on 1/1/1981 and thereafter on 9th of
1989.
February 1918? Why?
They can explain, madam. Maybe the pay scale there has been changed due to the long service.
Due to the long service.
Promotional benefit.
You show me from this list the ones who have received it. 3 to 8. 3 to 8.
This person was assistant manager. He was he joined as a senior engineer. Thereafter he became AM, assistant manager, and thereafter he became AGM.
So these were also notional. So for 3 and 3, 4, 5, date of appointment is more or less 7, same with that of respondent, I mean petitioner number 1 and 2. Yes.
But appointed as assistant manager, the remain same. And the other term was they are appointed as a junior engineer. If you get assistant manager, they are studying.
So they were appointed at a higher post, 1 and 2, from the beginning. Then
Then they have to get any two promotion they must get. If the promotional revenue is not there, to promotional financial benefit must be.
yes, sir. What is it?
My lord, renewing my prayer, I may once again draw your lordship to kindly come to the prayer made by the writ petitioner once, because that is very material, my lord. Kindly seize. And thereafter, I will invite your lordship attention to the order passed on March 2003, my lord. Kindly see the prayer once. Page number 21.
Promotional benefits and all
Other monetary benefit along with areas to the petitioner in terms of the order dated such and such, passed in writ petition such and such in the manner as shown in the paragraph number 18 to 25. So therefore, my lord, they are basically, my lord, instead of going to the contempt, they are basically trying to compliance of that order. So my lord, I will try to project, my lord, whether that order passed on, my lord, March 2003 was complied with or not, my lord. My lord, kindly see the order once again, my lord. My lord, I already seen, but nevertheless, my lord. Only one paragraph also. My learned friend had also taken your lordship through that paragraph, but perhaps that particular word has not been properly emphasized. That is in paragraph, page number, my lord. 37.
Yes.
Last paragraph, my lord.
Scheme and doctors.
Yes, my lord. In the facts and circumstances, I am therefore of the view that the selection grade introduced by the respondent authority is not insufficient. Very well, my lord. We admit to alleviate the grievance of the petitioner. As such, I direct the respondent authority to formulate a scheme similar to the nature which is applicable to the doctors of the FCI. So therefore, my lord, it is to be seen whether we formulated a scheme in parity with the scheme that is already available for the doctors or not. That is one aspect. Second aspect, so that the assistant manager of the engineering cadre to which the petitioner belong may get an opportunity to get promotion, my lord. There is no blanket order, my lord, subject to correction, that you have to give him a promotion whenever the 24 to 30 years has expired. What, my lord, the order says, my lord, that there has to be a scheme within the line of, my lord, in line of the scheme of the doctors, and so that, my lord, the petitioners or the equally, my lord, the evenly placed other petitioners may get an opportunity to get promotion, my lord. So may get an opportunity to promotion, and my lord, they will have to give a promotion 2 to 3 times within a gap of 24 to 30 years, my lord, subject to correction. There is a huge difference, my lord. So at least twice. So therefore, my lord, yes, absolutely twice, thrice. I'll show, my lord, even the other employees has been given 2 to 3 promotions. My lord, the case is not, this particular order was not limited to the petitioner alone, my lord. The order, though the petitioner, this particular petition was directed by 7 or 8 petitioner, ultimately, my lord, the hundreds of, my lord, the similarly placed cadres belonging to engineering cadre, my lord, employees would get benefited. So therefore, my lord, you have to see, my lord, the tenor and spirit of this order, whether it was limited to the writ petitioner or whether this order was limited to the scheme, so that the hundreds of other similarly placed employees get benefit or not. So that is why, my lord, this line 9 was, my lord, put into effect, that may get an opportunity to promotion 2 to 3 times. So once, my lord, I'll show, my lord, in terms of this order, my lord, we put into effect and scheme which was, my lord, subsequently, my lord, sanctioned by the ministry.
None of you are showing me the scheme.
Yes, my lord, I'll come, my lord. I'm just, my lord, giving a backdrop of the situation, my lord. Unless, my lord, to my satisfaction, I can bring these facts to the notice of this honorable court, my lord, I may not justify my client, my lord.
Because I've not yet seen the
Yes,
scheme.
absolutely,
So
my lord.
whatever you people are saying
Yes, yes, I'm seeing it
has
there,
to
my lord.
be in
Yes,
consonance with
absolutely,
the scheme.
absolutely. Yes, I'll come to that point, my lord. I'm just trying to show, my lord, the spirit and, my lord, the tenor of this order.
Yes.
So, at the cost of repetition, I may say, my lord, this order was not limited to repeat petitioner, so that he will have to give a promotion 2 to 3 times during his tenure. That my learned friend is, my lord, agitating. So, my lord, the scheme was put into effect. Before I place that, may I again say, my lord, this scheme was put into effect, and in terms thereof, my lord, the sanction strength of the employees had been increased from time to time, and all the employees, my lord, got benefit of promotion 2 to 3 times, including the writ petitioner. Why the writ petitioner did not get, my lord, 2 to 3 times? Because, my lord, he superannuated in the meantime. My lord can easily, my lord, appreciate the fact the person who has already superannuated, how can I give him a promotion even with a notional effect? My scheme has been put into effect from June 2003. Why this cutoff date has been given, my lord? Again, I say this the order of the single bench, which was, my lord, affirmed till Supreme Court, was passed on March 2003, and 3 months time was given. So, in course of, my lord, litigation, few years was, my lord, expended. That is why given a retrospective effect from the year 2008 to June 2003. My lord, 3 months time taken was liberty was given to us. So 3 months extra time we had taken, my lord. Therefore, my lord, June 2003, the cutoff date was given, my lord. And within that time, my lord, the petitioner was found to be entitled only one promotion that he has been given. Thereafter, when, my lord, the petitioner should have been given a promotion, by that time he
But
already.
sir, in the chart that you have prepared.
Yes, and not only that, my lord, I'll
So
show.
let's come to the chart once.
Yes, my lord.
Now, in page number 43.
Yes, my lord.
So the date of appointment of
Yes,
the
it is there,
person
my lord.
in serial number 1 is 29/10/1976.
Yes, my lord.
And the number 3 had been 34/1976.
My lord, I'm sorry, my lord, page number
43
Oh, I'm sorry, I was looking.
to your supplementary affidavit.
Yes, my lord, 43. Yes. Yes, PD one is Master PD Bansal, one of the
Yes.
petitioner.
Now, date of appointment is 29th of October 1976.
Date of appointment. Yes, my lord.
For number 3, who according to them
Yes, April
has
76.
received the benefit,
Yes.
date of appointment is 34/1976.
My lord, date of superannuation is to be seen, my lord. Then,
Where is it?
my lord, he has been given one promotion. He has also given one promotion, my lord.
No, he has been given 2 promotions.
Yes.
ACMCE, AGMCE.
Yes, my lord. He has been found to be, my lord, the last
So he
promotion.
has been appointed in the post of junior engineer.
Yes, my lord.
And the petitioner number 1
Yes.
had been appointed in the post of AMEE.
Yes.
What
Assistant
is
manager.
that? Assistant
Manager, my lord, electrical grade. Yes, cadre.
And thereafter, you have given him the next promotion to be AGM, Assistant General Manager.
My lord is reading serial number 3.
You see the appointment in the post, then details of promotion, details of selection grade benefit,
Yes, yes.
right? So, the person who is in serial number 3 was appointed on 30th of
Yes.
April 1976
Yes.
prior to the person in serial number 1.
Yes.
So for them, the date of superannuation must be in the year after 60 years.
Yes,
I
my
mean,
lord.
not prior to that.
Yes.
Now, if this person,
No, my lord, 60 years, my lord, may not be. He may come at a younger age, my lord. The date of appointment, my lord, if he joins the post in a later date, my lord, in a later age, I should say, then the date of
Right.
superannuation may not match, my lord. Somebody, my lord, joins a service at the age of 21, somebody may join a service at the age of 30. It may happen, my lord. I have to check, cross-verify, because from the available information,
Yes, the data doesn't provide the
yes, very well,
age
my lord, I
as
can
well as
satisfy.
the
And
date of
secondly, for the
superannuation.
time being, I can say one thing, my lord, promotion, my lord, knows there is no vested right. Promotion is to be done, my lord, in
Now,
terms
in
of
the
the,
scheme, how have you formulated
yes,
the stages of
yes, that is
promotion?
there, my lord, that is there, my lord.
The stages of promotion in the
Promotion,
scheme?
yes, my lord, it is there, my lord, stages has been
Where,
given.
which page?
My lord, kindly, what happens, my lord, first the scheme is nothing but a board of directors meeting, my lord, where the scheme was framed and proposal was put before the ministry. So basically that is the scheme, and that scheme, my lord, can find from page number, my lord, from my supplementary affidavit from page number, my lord. Immediately after this, my supplementary 11. From 11, my lord, it starts. Thereafter, my lord, some
This
back.
is not a scheme, sir.
My lord, this is
One thing to cut short, page 22.
Well, this is the scheme in terms of the board resolution, my lord, board resolution where the scheme has been proposed. And thereafter, my lord, this resolution was put forward before the, my lord, this kind of, my lord, side remarks should not be made. I do not know whether my learned friend knows the courtesy or not.
My lord is asking for scheme. I am just
No, what sort of remarks he is being making. I do not generally make this type of comments. I am assisting the court, somebody is making this passing remarks.
Page 22, my lord, para 2.
When you will be asked, you answer, right? So this page number 11.
Yes, my lord. The page number 11 to, may I, my lord. From page number 11 to 15 is a board resolution. Where, my lord, this.
But then, sir, if it is a board resolution, it doesn't frame the scheme in its proper perspective.
Yes, my
It's
lord,
just the resolution to have been taken.
yes, how this is to be done, it has been discussed. Then I have to place the whole, my lord, resolution itself, my lord. The
A
history.
resolution cannot constitute a scheme, sir.
My lord,
Can a resolution constitute
yes, my
a
lord,
scheme?
this is the, my lord, the sanction strength, proposed increased strength, that all has been discussed, my lord. I can show, my lord.
So this resolution you had sent to the ministry
to
for
the ministry, my lord. Thereafter, we proposed, my lord, for the increasing the sanction strength up to 144. That was, my lord, partially allowed.
proportion. That was your proposal.
Yes, scheme. We have to, my lord, frame a scheme. Scheme has to be sanctioned by
So
the.
that means till date no scheme has been
This is
framed.
the scheme, my lord. This is the scheme.
Sir, it cannot be accepted. A board resolution cannot be constituted as a scheme, sir.
Well, a scheme has
What have
not
you
been.
written? What is the resolution here? Come to page
Yes.
15 of yours.
Yes, my lord.
The board of directors is requested to consider the proposals
Yes.
contained in paragraph
9 to
9 to 12
Hereby
above and accord its approval. The
Yes.
board is requested to pass the following resolution.
Resolve the proposal as contained in such and such is hereby approved and subject to further approval by the government of India. So this scheme, scheme is a mere misnomer. The term has been used by the learned single bench, and we have also used. Scheme has never been defined, or not there has been specific format that this is to be scheme. We all, draw a figure in our mind that this should be the scheme, and this way the scheme is to be formulated.
So the proposal of a board for approval is a scheme.
Yes, in our understanding, in our formulation, this was the scheme, and why this resolution was adopted and why the resolution was made, that has been discussed, If desire, I can place this, the facts and figures, how the present existing strength and how the increase of the strength is to be done. That all has been discussed here, Maybe the word scheme has not been used, but that doesn't, take away the color of this,
Sir, your color is expressed in paragraph 12 in page 14.
As per the court order such and such, a scheme has to be formulated within 3 months. Thereafter, it has to be implemented. Therefore, these posts have to be created with retrospective effect from such and such, that is after the period of 3 months of the judgment, so as to consider the petitioner, including who have retired for promotion to the higher post. The post will be filled up as per HCA such and such. The proposals are hereby concurred by Executive Director Finance, So this is, the scheme.
This is a scheme.
Yeah, this is the scheme, that we have formulated and we have placed before
This
the.
is a scheme you have formulated.
Yeah, we have formulated and placed before.
Then, sir, I think I need to go back to school to learn again. This is.
In terms thereof, that is why, the government has also approved this, proposal. Unless and until, my lord, we formulate a scheme, my lord, the government can, it is a policy decision, my lord. What would be the sanction strength? What would not be the sanction strength, my lord? It is absolutely within the prerogative of the ministry. And therefore, my lord, even though we proposed for an increased sanction strength, my lord, it was not, my lord, approved by the ministry in toto. So therefore, my lord, the proposal for 144 was not approved, and therefore, thereafter, my lord, the total, my lord, sanction strength was, my lord, 484. It has been, my lord, kindly see the approval. Page number 21. That is the approval came from the ministry. On the basis of that, my lord, board resolution, which we are calling it, my lord, scheme, that in terms thereof, my lord, the ministry had passed this, my lord, the sanction letter.
Where is the sanction letter?
My lord, 21, my lord. Government of India, 21. Ministry of Consumer Affairs, Food and such and such, my lord. I am directed to refer to a letter dated such and such, and of the above such and convey the approval of the competent authority to restructure the engineering cadre. The restructuring of the cadre is to be done in a manner that it result the number of posts in the ratio of 1:6:4 at the levels of DGM and above, AGM and manager respectively. The number of posts to be considered at different levels for which the concurrence of IFD has been obtained as below. Thereafter, my lord, the sanction strength has been approved, my lord. It is not mentioned. I have a figure, my lord. The post from manager and above has been increased. Initially, my lord, it was, for example,
You come
12.
to page 22.
Yes, my lord. In terms thereof, we passed this, my lord, order. Once the sanction came, my lord, from the ministry, thereafter we passed this, my lord, office order. Sanction order number such and such. In terms
But
of,
then it doesn't mention the promotional avenue.
my lord, the post has been increased, my lord. So post has been increased. Kindly see, my lord.
Increase in post doesn't denote the
That
avenue
unless and
of
until, my lord,
promotion.
higher post, number of posts increases, my lord, the avenues will
Then-
not open. So this is,
That's exactly what I am asking. How have you structured the promotional scope?
my lord, first the manager, thereafter, my lord, the assistant manager, assistant general manager, thereafter deputy general manager. It has been there, my lord. Kindly see the previous assistant general manager sanction strength was 5. Now the revised.
No, you come first executive director.
Yes, my lord.
General
Executor,
manager.
each zone, my lord, one executive.
Fair enough. We are not on that. General manager, deputy general manager, deputy general manager, assistant general manager. What is civil electrical? Manager.
Left-hand
Where
side.
is this junior
On a
engineer?
junior level, my lord, it has been decreased so that, my lord, the higher post is more created. Kindly see, because total sanction state we cannot
The
disturb.
person who was inducted as a junior engineer,
Yes.
what happens to him?
But it has been from manager, my lord. Kindly see the manager. Thereafter, my lord, assistant general manager. It was
So
5.
now junior engineer is included in the post of manager.
Manager, my lord.
Junior engineer at the level of
Junior,
So
I
wherever-
am told junior manager and manager is, my lord, more or less the equivalent rank. Subject to correction, my lord. My client has not is here, my lord. I am told, my lord, general manager and manager. Nowadays there is no post of junior manager. It's all manager. Previously, my lord, it was technical assistant grade 1, grade 2, grade 3. Now it's all manager.
Now
There
for
is no.
junior engineers, if they have been accorded 2 promotions, so thus proportionality should be maintained in the case of the petitioner number 1 and 2 also.
Yes, my lord. That
So
keeping.
what is that structure?
Much structure this, you kindly see, my lord, subject to correction, my lord. Kindly see on the left hand side, the existing strength has been mentioned and the revised scheme, my lord. Revised sanction
The
is.
sanction, strength, number of posts
Then, my lord, I have to place the FCI regulation, my lord. How the promotion is to be. FCI regulation has not been disturbed. How the promotion is to be effected, that is already
asking
there.
you, what are the promotional avenues?
But that is separate aspect, my lord. That is, my lord, regulation.
That is their issue.
My lord, that is,
Sir, you get yourself clarified first. You said since they had retired, right? Since they had retired, there was no scope for them to be entitled to further promotion.
right.
Right? Now, as far as the date of birth is concerned, I pointed out.
Yes, my lord, I've seen. I'll clarify
Right.
that point.
Now you said, fairly taken, that they must have joined at a different age. Right? Therefore, their date of superannuation
May not match.
would
Be different.
proportionately be different if their age had been different
Absolutely,
at the time of the induction.
Absolutely.
right?
Absolutely.
So now whosoever was still in service from the point of initiation or induction, to be precise, as junior officers or junior engineers, they have risen,
Right.
right, through two promotion. They are seeking parity.
Other writ petitioners.
Other writ petitioners. Now, you are saying from AMEE, they had been given the promotion to AGMEE,
Yes.
electrical engineers perhaps. Then after AGM, according to your
Sanction.
AGM,
Yes.
you have DGM also?
Yes, AGM, DGM, GM, my lord. Yes.
AGM, DGM.
Manager, then AGM, then DGM, then general manager.
So now they are saying that they had been given one AGM, then they should get the promotional benefits with regard to the DGM. Though they have not specifically mentioned, this is what I could derive.
Yes, their prayers, sir. 2 or 3 promotion they are seeking for. 2 or 3
So
promotions.
DGM is also there. Revised sanction post 12. There is no explanation. You are saying they will not get.
By that time, my lord, what I can see from the facts, my lord, by that time he superannuated. Before the date of superannuation, my lord, we have to see his career progression, my lord.
So where
Only
is
one
it?
promotion we could have
Where
given.
is it? That has not been stated in your table. You
The
must.
table is the
Why? And that too after functioning in the AGM level. When does the next promotional time
I
or
can show, my lord.
scope
Today I am not
comes?
carrying. I am aware of FCI regulation deals with the promotional aspect.
So after serving for how many years
There,
from AGM, one gets promoted
produce,
to
my lord.
DGM.
I will produce, my lord.
So if that falls
I'll produce.
prior to the date of his superannuation, then he is entitled to.
Certainly, I'll satisfy, my lord. I bow down to your
Please do
lordship,
that.
my lord. These are pertinent questions. Definitely, I'll try to satisfy, my lord.
Only one question.
In that aspect, I can say, my lord, the promotion, my lord, is aware of. It's not a vested right. Unless and until he was found to be eligible, my lord.
Whether you had exercised
Yes, my lord, my lord.
that endeavor to find out his eligibility
Certainly.
to receive promotion or not.
To my information, it has been carried out, but nevertheless, my lord, satisfied.
There must be certain criteria whether he had fulfilled them or not, whether you had taken any steps in that regard.
My lord,
These
I'll
things
satisfy.
needs to be seen.
Certainly, my lord, I'll satisfy, my lord. I try to satisfy.
Heard the submission of learned advocates representing the petitioner as well as the respondent FCI at length. Now, do you want me to specify what are the queries?
No, I
Because in certain cases, I find that
if
on
my
the
lord
next
desire, I
day-
do not have any objection. I do not have any problem, my lord. But
there's not
I
question.
am
I've
aware of
given you
because I have
a lot
to
of
reply.
time. I have other matters also.
Because I have to reply, my lord. I have to keep it, my lord. Remember.
You keep it in your mind then.
Yes. Deeply obliged, my lord.
Next
My learned
date,
friend is also there. If I make a mistake, he'll point out. Deeply obliged.
I kind of spoken out what he wanted to say. Next date we fixed on 17th of November.
Deeply obliged.
Yes, sir. So you wanted a DGM posting.
DGM.
That you didn't say.
Several board of directors.
That you didn't say.
several
Next.
board of directors meeting has taken place, my lord. Already in record in the supplementary evidence.
That was 23, my lord, I appear for the day. But blood, at the very outset, my lord, I need to apologize, my lord. Your affidavit is ready. Today it will be affirmed. Advance copy, my lord, I have the advance copy. Affidavit in opposition as per your lordship's direction. But if your lordship says, sir, I can serve, my lord, the advance copy of this both the sides.
You served it to him, sir.
Mr. But I have already handed over.
So when you will file it?
But today it will be affirmed. I have served. Let them file reply to that.
The learned advocate representing the state.
I'm sorry, my lord, out of time, my lord, kindly pardon.
You do this every time.
No, my lord, out of time, my lord, I am tendering apology for this. But I had to obey the order of the court. But since my lord, some late, that I am tendering apology for this.
The learned advocate representing the respondent intends to affirm the copy of the affidavit in opposition to be filed in the court today and
30.
Copy of the said affidavit in opposition has been served upon the learned advocate representing the petitioner, who is to file the affidavit and reply on the next date of hearing. Next date we fixed on 18th of November. The learned advocate representing the respondent number 7 is present. Next.
I'm deeply obliged to your lordship.
Sir, you will affirm it and file it today.
Today, my lord, it will not be filed. It will be handed over at the next date of hearing. Today, it will be affirmed. Where I will file, I will have to, my lord, submit before your lordship. When the next
That got recorded, that you will
Yes.
file, that got recorded.
today, your lordship desire, I can file it before your lordship's court officer today.
Then you can't to him.
I
Prior
can-
to that, if you can affirm it, then you can file it.
Yes, after affirmation, I will file before your lordship's court officer. This is your
Tell you to 2 p.m. code.
No, your lordship pass the order, but I will, but I'm ensuring, Lord, I will submit before your lordship court officer.
Okay. Next.
কবে থাকবে এটা 18 November.
29.
Yes, madam.
Lordship, written notes, let my learned friend serve me a copy and I'll give it the next day, Lordship, because both of us were
You are not filing the written notes? You will not file. Then why did you take time? What about you, madam?
I have filed an exception, Lordship, that is akin to,
It's
but
in a-
then, because the exception to my learned friend had filed to the report, I have filed an opposition to that. So that more or less explains the entire circumstances. But if my learned friend files a written note, I'll also file it, because without, I was waiting for his copy, Lordship. I mean, if he served me, I would have.
No, he is not. The learned advocate representing the petitioner declines to find the written notes. The learned advocate representing the Respondent Union of India is present. Hearing concluded. See. Next. Next.
May it please your lordship. According to your lordship's direction, few documents that was not in proper order, that was in Hindi vernacular. Your lordship was pleased to pass a direction so that all those the documents would be translated. The translated copy would be filed. This is the document which has already been translated. The annexer mark has already been mentioned over there, Milord. All those documents, Milord, appear.
So he, in this, basically has given his statement of reply.
All are not relevant, Milord. I think that all are not relevant. I will, Milord, refer few. Milord, in a nutshell, just I am placing. We have challenged the propriety of the order of dismissal. Subsequently, we preferred an application, statutory application, which I am entitled to prior to confirmation and the post confirmation. Post confirmation I have filed under section 1172 of the BSF Act. After filing this, Milord, they have passed an order by the confirming authority. So here, my lord, the order of dismissal has been challenged and the order passed by the confirming authority has been challenged. This matter has been taken up by my Lord Justice Pratik Prakash Banerjee as his lordship then was and passed an order dated July 16, 2019. It appears from the order dated July 16, 2019.
Which page?
My lord, that is from the, my lord, the order sheet from my lord I am referring. Order sheet. That this is not the part.
You tell me the.
Date is, my lord, July 16, 2019.
Yes.
This is relevant. My lord, kindly see the third paragraph. My lord.
July.
July 16, 2019.
Yes.
Lord, kindly see the third paragraph. The petitioner challenges inter alia the appellate decision of the statutory authority under the provision of the Border Security Force Act of 1968. In order to test the appellate's order and the by way of a judicial review, it was imperative that I go through the statutory appeal and the other order passed thereon. The order passed thereon is in the English and at page of the 42 of the affidavit in opposition. The statutory petition which would contain the fact and the ground of the appeal to be preferred is not in a language which is admissible before the Chartered High Court in exercise of his jurisdiction under Article 226 of the Constitution of India. Neither has it been translated into the English as required under the rule. Mr. Datta, on behalf of the such and such, unconditionally submit an apology for the mistake and the crave leave to file supplementary affidavit disclosing the due translation of the statutory appeal.
So why are you referred to this?
So I am referred because, my lord, kindly consider the statutory, my lord, the supplementary affidavit, which need to be considered, which I already filed.
Let us go into the merits of the case.
Yes, my lord, I have to, my lord, I have to place this, my lord.
Why?
So far is the, my lord, the supplementary affidavit is concerned.
What has been mentioned there?
In the supplementary affidavit, the point has been taken that the, my lord, the few witnesses have been examined. Out of the 3-4 witnesses, one relevant witness, A. Kumar, was also there. He categorically stated that while, my lord, the incident occurred at night at 12, intervening of the 2 days. While, my lord, the petitioner before your lordship has handed over the charge to the, my lord, the next person, he inspected the, my lord, the area of responsibility, entire bordering areas. Then he left and taken charge. After went out, my lord, after 20 minutes, the person who has already taken charge, he reported that in some areas there is a cut-off fencing. So in that area, my lord, in second, anything can happen. So when he has taken charge, he has inspected the entire zone, and having been satisfied, he has taken. That has been reflected in the, my lord, the deposition of the Mr. A. Kumar.
The one you have given today.
No, my lord, that is already there. That is already there. I will place.
No, the translated copy.
Translated copy, my lord, my representation is there. So this point has been taken in the representation. So that ought to have been considered by the, my lord, confirming authority or the appellate authority, whatever might be. But that, my lord, the aspect of the deposition never been considered. So, my lord, the evidence which is in my favor not been considered while considering the confirmation petition. In that event, it is a perversity. So that aspect has not been considered, although there is a specific deposition of the A. Kumar, and who has, my lord, in the relevant point of time has been posted in the same location. Lord, that view has not been considered. So my case is only, my lord, the 2 or 3 issues. One is there is an undue haste in the decision making.
Hey, Aditya.
So the challenge was undue haste in taking decision making, my lord. There is a duress that who would be appointed because I have taken the point also the rule 57 also not been complied with, the friend of the accused. Other is, my lord, rule 58 has not been complied with. So in my pleading, I has categorically made out a case that this is a case of undue haste, because while he was in the confinement, in the, my lord, the close arrest, he has not been given an opportunity so that he can consult with his learned advocate. He has expressed it. So, my lord, when the matter was taken up previously, it was fallen from your lordship that, my lord, it appears from the, my lord, the timeline which has been given, it appears that very short timeline, my lord, everything has been done. So it appears from the document itself that the basic minimum reasonable opportunity which ought to have been given to him, that has not been given. So that has been mentioned in the paragraph 26, 27 and the 12 in my writ petition. Apart from this, there is a real likelihood of bias also, which I have taken the point in the paragraph 16. They have also dealt with, but categorically this point has not been dealt with by them. So although, my lord, the reasoning is not required to be given, in consonance with the dictum which has been laid down by the Honorable Supreme Court in the, my lord, Dinesh Kumar, that in a summary security force court, the court is not obliged to give detailed reasoning. But so far as the rule 148 is concerned, you have to give the opinion. So far as the finding, you have to give whether he is guilty or not guilty. Apart from this, no reasoning is required to be given. But the rule 148 says that you have to give the opinion. Where you have to give the opinion, you have to consider the evidence which I have given and you have to deal with the evidence. That has not been done. So this point has been taken before the appellate authority or the confirming authority. So that's why, my lord, Justice Banerjee told that you file a document so that it would be, my lord, clear or the explicit from the document itself which has been submitted that whether this point has been taken you or not. So, my lord, kindly take trouble to have a look at my supplementary affidavit which I have filed. Performed on, my lord, 13th of August 2019.
Yes.
My lord, representation is appearing at page 6.
Page 6?
Page 6 of the, my lord, the supplementary affidavit, but the, my lord, the internal page is 84.
Performed on 13th of August 2019.
Performed on 13th of August 2019.
There are only 5 pages.
Consists of, my lord.
Is this the one? It has only 5 pages. Yes.
My lord, kindly have a look at the representation internal page 2. So I will not place paragraph 1 and 2 because the fact has been deliberated upon. Only I will place the relevant portion at page 3. Paragraph 4. About 5 to 2 minutes. My lord, got it? Page 3.
It starts with true copy of memo.
Yes, true copy. Annexure 14.
Annexure 14.
14. Copy annexure 14. Because this is the typed copy, translated copy.
You are referring to a different document.
Yes, supplementary affidavit. Yes, but the annex, these are the annexures. Just see this document, my lord. Yes, sir. It starts from this page. Representation starts from this page, page 84. Just I am referring internal page 3. Thereafter, internal page 3.
Yes.
Paragraph 4. About 5 to 2 minutes, about 5 to 2 minutes before, it was 24.00 hour at night. Head Constable S. Kumar 82 BNBSF came to me and I handed over the charge of the area, radio set, etc. properly to him. He checked the area. When he told me that the area was all right. I left the area. I reached the BOP, border outpost. After 15 to 20 minutes, Head Constable S. Kumar came to me in the camp and said that the 3 wires of the improvised fence near 246 main BP in your area has got snapped, causing a gap of 6 feet. There are the loop mark of the 10 to 12 cow along with the foot mark of the 1 to 2 persons. And you did not tell that to me. I told him the wire of the length of the 6 feet has got snapped and you checked it before, but you could not notice it. Now you are openly blaming me. So this point has been taken in the representation. Should I read later on, minute? In spite of, I told them that I should inform him the CME chief complete
Yes.
conduct.
Why did you want to project this?
Because this is, I have taken this point in my representation before the confirming authority, what I have stated before them. The confirming authority ought to consider this aspect and the relevant provision and the witness, so far as the deposition is concerned also. I will refer from the Lord confirming authority.
What was the punishment?
Dismissal from service.
Yes.
Then, Lord, I will refer page 42 of the affidavit in opposition. Page 42.
Yes.
Relevant portion, Milord, because it is long one. Relevant portion, I am referring page 43. Last paragraph. Milord, got it?
Yes.
Constable Lingaraju, P7, deposed that on the intervening night of such and such while they performing the first shift of the ACP duty in the between such and such hour, he had seen the petitioner moving towards the point number such and thereafter Sia Ram Rao went to the point and after that they both and they did not return to the original point of the duty.
Which page?
Page 43 I am referring.
Disposal of petition.
Disposal of petition, it starts from Milord page 42.
There is a difference in pagination.
It starts from page 42. This is the order passed by the Milord confirming authority.
Page 44 mentions this. Constable Arjun Kumar.
No, page 43, last paragraph, continuous Milord, I am reading.
Feeling aggrieved.
Constable Lingoraju, P7, disposed that on intervening night.
That is 44 in this.
In my page 43, Milord.
But here it's 44. Yes.
That the intervening night such and such while performing the first shift of the SCP duty in between such and such.
Anyway, you tell me what are the lapses apart from this?
This point has not been taken into consideration. Kindly see the relevant portion when that has been mentioned. They have admitted that this thing has been happening.
He visited the spot in the morning and found 3 strands of fence cut by smuggler. Hoof marks as well as human footprints were clearly visible on both sides of the breach portion of fence. There were 10 to 12 hoof marks. So this is what was not informed.
No.
You did not inform this. After detection.
This incident was not happened during my tenure. I have categorically stated They have
Tenure or your duty during your duty hours?
performance, performing my duty. Because the tenure is in the entire day, 8 hours shift is there. So during my the service, when I was performing the duty, that tenure nothing was happened. So they have taken it, they have taken the charge. Subsequently, they have checked it, everything was fine. Okay report was given to me. Subsequently, after 20 minutes, in the border like this below IB border, anything will happen within 20-30 minutes. So thereafter, they came and alleged that this thing has been happened. So this point
We'll come to page 46 perhaps in your papers. Who approached the smugglers, shouted at them, challenged them by...
No, this is the different witness, Mirror. The different witness has stated.
So you went and challenged them?
No. So in that
you approached the smugglers?
Yes.
You approached the smugglers?
No. This case has been they have deposed other witnesses.
Other witnesses?
The other witnesses are also there. Other witnesses deposed that this incident has been happened and that has been reported. Subsequently, it is not during my while I was performing my duty. So I intend to draw your lordship's attention to the fact.
Ashwin.
Mr. Mitra is appearing, my lord. Today he is appearing before the Honorable High Court at Meghalaya, my lord. I'm praying for a reply, time for reply, my lord.
On the earlier occasion also, your senior was not there.
My lord, kindly see this order of the Honorable High Court at Meghalaya, my lord. Yesterday and today is fixed for my the hearing of
the learned heard the submission of learned advocate representing the petitioner. The learned advocate representing the respondent of India is not present. You prepare a short note and give it to me on the next date. Next date, he fixed on 17th of November. Filing written note by the learned advocate representing the petition.
I will refer the judgment also. I have already relied on.
Next.
Lordship, in this matter, I beg to appear for the petitioner. Mr. Aditya Mondal, he is advocate on record. There is a certain bereavements in his family. I have instructed through phone to seek before your lordship for adjournment.
Ashwin. Sir, what is the issue? On last occasion, it was fixed for orders also, I've seen.
This is relative to the.
But thereafter, they came and say that is there in the order sheet. Yes, sir. What is the matter?
Removal from service of the CRPF, Lord. Overstaying from the leave, overstaying of the leave, Lord. The petitioner before your lordship, actually, Lord, he went on leave for granted by the authority to attend the marriage ceremony of his sister. Therefore, he did not turn up. Then notice was issued. Again, he has made a representation before the authority to grant the another time for attend for treatment of his wife's leg fracture, Lord. Then that was not considered. Notice was given. They did not turn up. Then the overstaying for the leave. That's why, Lord, the departmental proceeding initiated. He participated in the proceeding. Every process of the departmental proceeding has been complied with. That's why, Lord.
ये और छेड़ा थी कोई मोबाइल का नहीं Yes, sir.
Affidavit, my lord, we have extended the affidavit. Your lordship, if granted me leave to file a written notes of argument that I. Have taken the all procedural in course of departmental proceeding. We have taken every step.
None appear to represent the petitioner. The learned advocate representing the respondent is to file written notes on the next date of hearing. Next date be fixed on 12th of September, sir. Next.
I will put the petition.
Madam, on your ground, this matter was fixed today. At that point of time, somebody told me there was a.
There was a mishap, yes. But Lordship, written note of arguments, Lordship, I have.
No, just tell me for my recapitulation.
Lordship,
21st.
21st. 21st June it was filed. My written. July, Lordship, I had filed the written notes of argument. Lordship, is it with your Lordship?
What is, yes, sir, what is the issue?
Okay. My lord. Penalty, my lord.
Penalty?
Penalty challenge, my lord.
What kind of penalty?
Reduction of payment.
Reduction of fee. One stage.
One stage. What was the charge?
Charge, my lord. That is a.
Fail to protect plant property, Lordship. There was a.
That is page 19, my lord.
Back outside the perimeter wall. Iron scrap was to from his duty post. Lordship.
Okay.
My lord, kindly recall. Next page, my lord. He was duty from.
Yeah, his duty was over by 5
My lord.
p.m. or something.
Serious witness.
And then you said it occurred after 2 years, 2 hours something.
Serious, my lord.
Hearing concluded. Okay. Next.
Copy আমি পাইনি দিদি।
My lord, I am for the, my lord, the respondents.
Yes, sir.
Pursuant to your lordship's direction, my lord, I am filing this report in the form of an affidavit.
What is the report?
So, here your lordships has directed us to state the details of the promotion and benefit we have given to the petitioner.
Have you at all given them any benefit?
Yes, yes. Rather, my lord, we have given more benefit. More. Because his due is 2014 for second promotion. We have elevated in the year 2009 and we have the space scale and the grade pay they have demanded. So, if your lordships go through the report, my lord, everything will clear. I have handed over the.
You are leaving it to me to go through it.
No. My lord, I will place. I have given everything. His promotion due is, my lord. Now he has already given third promotion. I think, my lord, the writ petition is become infructuous right now because they have all.
You show me the page and the column where you have stated about the promotion
Well,
and the sequence in which
yes.
the petitioner is entitled to.
My lord, kindly come to my opposition or
the report, which will be easier.
my lord, kindly come to page 7, the chart.
Yes.
The first promotion we have given, my lord, on 16 December 2006.
Right.
Thereafter, his next promotion due is 16 December 2014 because your lordship knows 889 and then, my lord, 23.
Right.
Right. Now, my lord, what has happened? After giving first promotion, because initially they have joined the grade joined of my lord, grade pay is 2,600, then first promotion 3,600, then on 2014 they are eligible for second promotion with grade pay of 4,400.
Right.
Now, my lord, after ROPA 2009,
Yes.
the authority took a decision to get them at par with the others because they are the ITI, Madhyamik and is say school final and ITI. There are two parts and others are, my lord, the diploma engineers. That is why, my lord, on 1st April 2009, they have been elevated.
1st April 2009.
Yes.
Yes.
Elevated to special operating assistants. My lord, kindly see, their pay was changed, everything was changed.
9250.
Yes. And grade pay was same because in the order of elevation, everything same grade pay. Now they are entitled second promotions 2014 that we have given. Now 2003 promotion they are entitled in 16 December 2023. And your lordship knows the so far ROPA 20 is concerned, everything was changed because grade pay survey that your lordship knows, my lord.
So now what are they claiming then?
Well, actually they have claimed that when we have elevated, they should have, my lord, at par with the diploma engineers. That is
the ITI
school final with ITI. Well, they cannot be equated with the BSc or diploma engineer.
At the initial stage.
Initial stage, my lord, two parties there. Their appointment is school final with ITI, with grade pay, different grade pay and different scale of pay. When we have elevated them, they try to equate with the diploma engineers. That is their claim.
Once you have given them elevation,
yes,
they are being given the benefit of 9250.
9250.
Right, pay. So what was the others given?
Well, as well, others are, my lord, they're different. That they are different procedure. Their grade pay is different because they are
So
the higher quality.
that grade pay.
Yes, they are higher scale. Their initial lateral entry is higher than the petitioner, so they cannot be equated with the others. And, my lord, they are. I have stated everything in ROPA 2009. What is the path of promotion? Everything is there. I have given the details. My lord, kindly come to page 53 of my report,
53.
which you have stated in details.
Office order number 255.
No, my lord, the ROPA 53, page 53. It's a
There
ROPA
are two pages, two numbers on the pages. Existing provision, this one,
Yes.
clarification, modification.
clarification modification. Page 53. My lord, clause 20E XII.
Yes.
For such employees who are holding the post of special operating assistant grade B and special technical assistant grade B and where are not possessing diploma in engineering or BSc degree and who have been redesignated as senior operating assistant and senior technical assistant respectively as above, and for such employee who are holding the post of junior operating assistant, junior technical assistant as on 1st April 2009, for whom induction level required qualifications was neither diploma engineering nor BSc degree, the path of promotion under CPS
Okay, sir.
will be as follows.
Yes, sir. What is your issue?
We have given more benefit. Now, my lord, subject,
File an
yes, subject to your lordship's, my lord, we can ask for refund. If really they, my lord, insist to proceed the writ petition, as per Supreme Court decision, my lord, we can ask for refund. If they really, my lord, proceed with the writ petition.
Provided
No, subject to your lordship kind consideration, of course.
arbitrary, iniquitous.
There is no arbitrary. We have given more benefit.
Ashwin. Sir, they are seeking parity with the
diploma engineers and.
Can you get their pay scale also, the grade pay and their pay scale at the?
But they are fiscal in from the lateral entry high.
Yes, that one. That
Yes,
portion.
yes, that we can produce. One
Because
or two.
their stream are different. Their
Different. Yes,
qualifications are
yes.
different.
Everything is different.
And their entrance eligibility
yes.
must also be different.
Yes, different. Because they have entered.
You just get that a sheet as far as the others are concerned, because as you said, they are seeking benefits from the date of their elevation at par with the
yes.
others. So what
Yes,
has been
because
there?
they are the more qualified candidate. Their scale of pay different. Their lateral entries.
That part.
Yes. That we can. No. In fact, we have stated in my report in details.
But then, sir, that comparative chart will be easier.
Yes. That we can.
Advocate representing the respondent, WBSEDCL, right, sir?
My lord.
Has filed the report in the form of an affidavit. Let the same be kept on record. The learned advocate representing the petitioner, being served with the copy of the aforesaid report, intends to file an exception to it. Next date be fixed on 21st of November.
21st of November. Because their induction level is 9, they are 5. That we can produce it.
Just a comparison.
Yes. Well, they are not eligible. My lord, only one request. My lord, kindly release the mobile because I have.
Sir,
my lord,
I've been telling this
yes.
every day. কোনটা দিয়ে দাও।
This is my petition, lad.
Yes.
For the respondent, they have filed their affidavit. This is my reply to their affidavit. Lad, in their affidavit, lad, they have reply.
Just give me your background.
Lad,
Briefly tell me what is it.
lad, lad, I am lad, ex-cadet, lad. I am an ex-cadet, lad. Lad, admitted to a school of army, lad. This is lad, NDA, National Defense Academy, lad. Lad, there, lad, I was detected. I was while I was undergoing my training, lad. Lad, before the medical board, it was detected that detected my disability, lad. Lad, in terms of the circular, lad, that is available, prevailing, lad, and I am entitled to, lad, get some ex gratia benefit, lad. Lad, that they are denying on the ground that this disability is not attributable to, lad, the training, lad. That's the, lad, allegation.
What disability?
Lad, generalized seizure, having, lad, 20% disability. The term is
It precluded you from receiving the benefit, the disability that you are
ex gratia
suffering.
benefit that they are saying. That is their case, that I am not entitled to benefit of ex gratia benefit in terms of the circular that is prevailing, since this is not, blood, attributable to the training or due to training, blood, this has happened, blood. That they are denying.
Before the lordship goes into the merits of the case, Malad, there's a maintainability point raised. Malad may kindly
Yes,
refer
Malad,
to Malad, order Malad passed by your lordship on 16th of April. Malad, it has been recorded. Because of lack of territorial jurisdiction.
If they take the point of mental, that then they have to argue.
That is already recorded, Malad.
Yes, tell me.
Malad, Malad, my point is, Malad, lordship may kindly see, Malad, the address of the respondents and the cause of action, Malad, entirely outside, Malad. This has been taken. Malad,
where was he serving?
Malad,
in
Pune. In Pune, Malad.
I was discharged.
Proceedings was held. I mean, where was the proceedings held?
Proceedings, Malad, not the proceedings, Malad. He was released from the service. Malad, I have mentioned in paragraph.
No, this ex gratia benefit to have been denied was a result of any proceedings instituted against him.
Since I was discharged from my service.
Why were you discharged?
On medical ground, because they had detected disability before the. Therefore, I cannot continue for the training.
Training?
Yes, but I was undergoing a training.
Probation?
No, this is not service. But we are cadet, ex-cadet.
Cadets?
Yes.
The rules does not apply. Malad, that is on the merits of the case. I will not go into that, Malad, at this moment, Malad. Malad, may kindly take, Malad, your lordship, if I may argue, Malad, on this aspect. Malad, page 2 of my affidavit in opposition, which has been filed.
Page
2, paragraph 3.
Yes.
But at the outset, I state that the said petition is not entertainable and maintainable before this honorable court, inasmuch as the purported cause of action of the petitioner, if any, on the basis of the facts as reflected in the said petition, arose in Indian National Defense Academy, Pune, Maharashtra, within the territorial jurisdiction of the Honorable High Court at Bombay. Moreover, the Office of the Pension Sanctioning and Granting Authority, where they have prayed for release, as prayed for by the petitioner, is also situated within the jurisdiction of the Honorable High Court at Allahabad. Therefore, in view of the matter, this Honorable Court, with greatest respect, has no jurisdiction over the matter, my lord. Lordship may kindly seize the cost title of the respondents, my lord. Address of the respondents, all outside, my lord. page 4, my lord, of the writ petition.
Because of his address of residence.
That cannot be under 226 200, cannot be, my lord. May I rely upon two judgments, my lord, on this aspect? It's my lord, 2004 6 Supreme Court cases 254, my lord.
Page.
29. My lord, kindly take, my lord. This has discussed the earlier judgment, my lord, passed. I have the judgment as well, my lord. My lord, sorry, my lord, I don't have that. Paragraph 28, my lord, page 263, my lord.
Paragraph 20?
28, my lord. As well as other paragraphs are also important, my lord. May I read it for your lordship, my lord? But the judgment, Kajur Singh versus Union of India, my lord, whereupon the learned counsel appearing on behalf of the applicant placed strong reliance was rendered at a point of time when clause 2 of Article 226 had not been inserted. In that case, the court held the jurisdiction of the High Court under 226 of the Constitution of India properly construed depends not on the residence or location of the person affected by the order, but of the person or authority passing the order and the place where the order has effect. In the latter sense, namely the office of the authority, which is no implement the order would attract, the territorial jurisdiction of the court was considered, having regard to 20C of the Code of Civil Procedure Code. Then, the paragraph which was quoted, the concept of cause of action cannot, in our opinion, be introduced in Article 226, for by doing so, we shall be doing away with the express provision contained therein, which requires that the person or authority to whom the writ is to be issued should be resident in or located within the territories over which the High Court has jurisdiction. It is true that this may result in some inconvenience to persons residing far away from New Delhi who are aggrieved by some order of the Government of India as such, and that may be a reason for making a suitable constitutional amendment in Article 226. But the argument of inconvenience, in our opinion, cannot affect the plain language of Article 226, nor can the concept of the place or cause of action be introduced into it, for that would do away with the two limitations on the powers of the High Court contained. Now, 29. In view of clause 2 of Article 226 of the Constitution of India, now if a part of cause of action arises outside the jurisdiction of the High Court, it would have jurisdiction to issue a writ. That has been dealt with. Thereafter, the forum convenience has been discussed in paragraph 30. We must, however, remind ourselves that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter on merit. In appropriate cases, the court may refuse to exercise its discretionary jurisdiction by invoking the doctrine of forum convenience. Or thereafter, the judgments which are considered.
Okay, let me fix it for orders.
That,
if you want to,
I have a judgment to rely on that. Judgment copy.
if you have a contrary view, you can place.
Which considers the judgment placed by my learned friend, right? In fact, on same facts of my case, my lord. Kindly take some paragraph 4. Right, rather paragraph 3. It is contended by the appellant that after he settled at his native place at Bihar, he sent several letters representation from there to the respondents for his financial claim as per statutory provisions and terms of contract on the disability compensation claim. The respondent number 2, the corporation communicated by letter response that since the appellant was declared unfit for sea service due to heart problem, he will be entitled to receive so and so, which was although offered but not accepted by the appellant. Then the writ petition, paragraph 4. By filing a writ petition, the appellant approached the Patna High Court under Article 226 of the Constitution for grant of reliefs, including 100% disability compensation, pecuniary damages. However, at the time of hearing, respondent raised the question of maintainability of the writ petition on the ground that no cause of action or even a fraction of a cause of action arose within the territorial jurisdiction of Patna High Court, and contend that the appellant was appointed by the corporation on the post of seaman for offshore services and he discharged his duty outside the territory of Bihar. Now, in this context, court has held at paragraph 9 first.
Yes.
9 first 226 is quoted. Then next page, on plain reading of the amended provision in clause 2, it is clear that now High Court can issue writ when the person or the authority against whom the writ is issued is located outside the territorial jurisdiction. If the cause of action wholly or partially arises within the court's territorial jurisdiction, cause of action for the purpose of 226(2) of the Constitution for all intent and purpose must be assigned the same meaning as envisaged under section 20C of the Code of Civil Procedure. The expression cause of action has not been defined either in the Code of Civil Procedure or the Constitution. Cause of action is bundle of facts which is necessary for the plaintiff to prove in the suit before he can succeed. The term cause of action as appearing clause 2 came up for consideration time and again before this court. Then paragraph 17.
Yes.
Court draws conclusion. We have perused the facts pleaded in the writ petition and the documents relied upon by the appellant. Indisputably, the appellant reported sickness on account of various ailments, including difficulty in breathing. He was referred to hospital. Consequently, he was signed off for further medical treatment. Finally, the respondent permanently declared the appellant unfit for sea service due to dilated cardiomyopathy. As a result, the shipping department.
No, just this, it is said
ultimately
that
court has held that yes.
No, because the representations were
Made
from Gaya, Bihar.
And received. He made his claim from Bihar and he received rejection from Bihar. At Bihar.
What is your case?
Here also, Milad, impugned order, kindly see, I'm at page 35. This was sent to my resident at Kolkata. And I am agreed by this order only. This decision only. The same facts here in 2024. He was discharged from his duty and he returned back to his residence at Bihar.
Did you forward any representation?
Yes, ma'am. I have, in my case, I have also made claim, lad, and after considering my claim, lad, they have refused this. Lad.
So your representation was from which place?
Lad, just a second, lad. There was a statutory form. Lad, 32 is the lad. Lad, page 32, lad, that I was referring, lad.
Page 32.
32. It refers to my application and refusal, lad.
No, that is, I'm asking you, from which place did you communicate to them? Representation was there from your part?
That I made that application.
From which place?
While I was staying at Kolkata, because I was.
Where is that copy of the application?
Copy, blood. I don't have a copy, blood. They must be having.
You have not kept a copy.
The statutory formula that I have given to them. But the form which I have filled up, that was forwarded to me by this communication, space 32 at Kolkata. I received that form and thereafter I have communicated to them, which was subsequently rejected.
What is your writ petition for?
But for ex gratia benefit in terms of the circular of 1996. And they, by this page 32.
How long did you serve as a cadet?
1 year.
Are you supposed to receive?
Yes, circular says so. But I have annexed in my reply.
Okay. Let us first decide the issue of maintainability as you have.
Yes, and also, this judgment, it is specifically says, it has to be the integral cause of action. The integral cause of action has to be within, even if you rely upon. Here, everything is
Heard the
outside,
learned
nothing is within.
advocate representing both the parties on the ground of maintainability.
Paragraph 16 of the judgment, which has been cited
Next
by
date
the learned
fixed
friend,
on
the answer,
16th of September for orders.
I'm so grateful.
Okay.
Next.
Lordship, in item number 53, I am appearing for the petitioner, Lordship. Lordship, respondent number 2 was to file a report, Lordship, which we have not been served with a copy. I don't know whether they
One
have filed any.
rectified report.
Yes. My learned friend has any of his colleagues here, I can serve him.
Lordship, nobody is there. I will send my clerk to his office, Lordship, to receive one, Lordship. Lordship, we intend to file one exception, Lordship. Kindly grant some time.
The learned advocate representing the respondent number 2 in compliance with the order dated 23/4/2025 and 28/7/2025 has filed the report. Let the same be kept on record. Sir, otherwise the pleadings are completed. A copy of the report is to be served upon the learned advocate representing the petitioner. So who will come and who will go is your internal arrangement.
That's not a problem. We can manage.
Next date be fixed on 18th of November for hearing.
Grateful, Lordship. Grateful.
But I am for the respondent. But only thing, may I draw your lordship's kind attention of lordship's last order, whereby I short for the time to file the objections to supplementary affidavit. Which is yet to be filed. I am seeking 3 weeks more time to file because
you need not file, sir.
No, because my instruction is from the department to file objection. Secondly, yesterday evening, another late afternoon, we have been served the copy of the reply affidavit.
So that
So
doesn't.
we have to take instructions from the client.
So
We are
that's
seeking
different. That's
3 weeks time.
different. On 5th of August, sir, you had
Lordship.
sought for time
Lordship.
to file objection to the supplementary affidavit.
So we are at the verge of completion of our work. So kindly give us 2-3 weeks time to submit. Kindly take up this matter after vacations, because on the other
What
points.
is the matter?
That is the petitioner dismissed from service in the year 2009 without hearing. Disciplinary proceedings, the petitioner did not unable to appear, and order for dismissal has been passed, challenging that one writ application has
You
been
did not appear.
No.
Why?
That is as per instruction of my client, no notice has been served. He did not receive any notice.
He was dismissed in which year?
In the year 2009.
And you have filed the writ petition in 2022.
Subsequently, 2 writ petition has been filed, and my lord, 1 writ petition, liberty given to file appeal. Appeal has been preferred. Then appellate authority, without any reason ground, my lord, only devoid of merit, straightway dismiss the.
What was the charge against you?
Charge, my lord, at the time of appointment, my lord, I produce fake caste certificate. This is the only charge. 2003 appointment given, 2000 after 6 years, in the year 2009, my lord, they dismissed from service without hearing me, and I annexed all the my lord caste certificate in the writ petition.
You were not aware that you had been dismissed.
My lord, no notice has been received, and my lord, one
You
criminal
did not even go and try to find out.
My lord, then my lord, appellate in the petitioner file on writ application.
So what were you doing? You did not attend office.
My lord, after that, my lord, first suspension, then dismissal from service.
So suspension must have been for a limited period of time.
My lord, that I here, my lord, I took a ground that no notice has been, no.
No, that was something you are disclosing to the court. It's in the form of a subterfuge. What I am asking you is, you were not in contact with the office or the department wherever you were serving.
After that, my lord, in the appellate authority, before appellate authority, I appeared before the.
Then from where did you get the notice?
My lord, after my lord, disciplinary authority passed an order, straightaway my lord, order has been communicated to the petitioner.
You were not aware that the disciplinary proceedings
no notice has been served. My lord, and in the inquiry officer, before the inquiry officer, that statement was made that notice issued, but where that was served or not, that no statement is there. Notice of hearing issued, while a notice served or not, no statement before the inquiry officer. Ex parte order passed.
Only on one date.
Oh, one day, only one day. They decided the issue. And revision authority also, my lord, affirmed the same. Only one line order. As there is no merit, straightway rejected my revision petition. But I have the caste certificate, my lord, from my father, and mine, my lord, I annexed all the caste certificate, and which was produced at the time of revision authority, at the time of appellate authority. But one line order passed without verifying the same. And from 2009, I am, my lord, dismissed from service.
You were appointed in which place, which department, or which office?
But he was appointed in the post of constable in CRPF. Central Reserve Police Force. What my learning friend submitted, we shall deal with these points definitely.
Is this the only issue, or there are other issues also?
No, the only issue, but while he possessed this service, the government service, he produced fake certificate, which was approved by district magistrate of North Chobbish Parganas twice. That these a report has also been, which was short for, report has also been filed by district magistrate saying that these certificates, caste certificate is fake. Based on that, we had proceeded with.
Chanchal. You have filed the affidavit in reply today? The learned advocate representing the petitioner has filed the affidavit in reply that the same be kept on record. When did you approach the appellate authority? Which year?
My lord, appellate authority.
Heard the submission of learned.
In 2012, pursuant to directions of
Of
this
the
honorable
High
court in earlier writ petition.
My lord, that is page 50.
Order of the appellate authority.
Dated 4th April 2012.
So you have filed the writ petition after 10 years, nearly
Then,
10 years.
Then, my lord, appellate authority challenging the appellate authority order, one line order, I file writ application.
Again.
Then writ application disposed of with a direction to give me liberty to file a revision petition before the revision authority. I file revision application and revision authority, my lord, one line by one line order, my lord, rejected my claim.
When?
My lord, that is.
Heard the submission of learned advocates presenting both the parties.
24th May 2022.
No, order dated 5th February 2015.
24th May 2022, that was intimated to me. 24th May 2022.
That was the intimation. It was the order passed by revisioning authority
63.
on 5th February 20.
You all of, I mean, the initial order.
Order of dismissal.
The order of dismissal, the order of the appellate authority, thereafter the order of the revisional authority. It was not communicated to him.
Everything has been, we have all records. We have served the address.
Moreover, when the process was being initiated by you, at the very initial stage, you did not give him a scope for hurry.
We have the document to substantiate this point also.
You had asked him to appear before you?
Yes. Every time we asked him. But he has chosen not to appear before the inquiring authority, before the disciplinary authority. That means before the appellate authority. That's why time and again he has come before this honorable court by filing a writ petition.
Okay. The learned advocate. Sir, I'll give you last chance for filing both.
Shall be grateful to you.
Because on the other occasion also, I asked you how long will you take?
So accordingly, this order has been passed on the last occasion.
And now again you are seeking time.
Not only my instruction is, but we are preparing this affidavit in the process of.
On the prayer of learned advocate representing the respondent. What is it? GRPF?
CRPF.
CRPF. Next date is fixed on 22nd of September for filing affidavit in objection to the aforesaid supplementary affidavit.
That's grateful.
Madam, you have given him a copy of the affidavit?
Yes, already.
Yesterday.
Next.
তোমার জন্য তুমি যাচ্ছ করবে কথা বল
I am appearing with petitioner. My lord, the sum and substance of this case, my lord, the petitioner prayer, my lord, refund the overdrawal amount which was deducted from the post-retirement benefits. This is the my lord, sum and substance of this petition, my lord. Earlier occasion, my lord, 4th August, my lord, the order was passed, my lord, the prepared a list of date. I have, my lord, prepared list of date, my lord. 27th December.
Petitioner was appointed in the post of constable.
CIS.
On 27th of December 1984.
84.
Thereafter, head constable after 10 years.
10 years, near about 10 years. And thereafter, my lord, the voluntary retirement 31st March 2019.
After completion of 35 years of service.
Yes.
Pension payment order issued such and such. Send a notice demanding refund of
overdrawal amount.
What was this overdrawal amount for?
Overdrawal
deduction was made deduction was made for recovery of the overpaid amount in the form of a salary, my lord.
as
From
deduction
which place, which time?
from 1993 onwards. At that
From
time,
1993, you were.
yes, ma'am.
Rupees
Rupees 5 was deducted, my lord,
Huh?
from each month.
my lord, this is the, my lord,
Rupees 5 from each month.
my lord,
Which amounts to rupees 11 lakh,
1 lakh, 1 lakh
1 lakh to 12,000.
12,148, my lord.
Okay.
Deduction
Chanchal.
was made as
My
per
lord,
section
my lord,
4 subclause 6 of the Gratuity Act, my lord. And moreover, my lord,
this
kindly
is
comes to
this is
page
the
22,
fact,
my
my
lord,
lord,
of my affidavit in opposition, my lord.
what is the reason for the, my lord, my lord, the petitioner got the salary, my lord, at the, after the, my lord, 10 years, got the promotion, his salary was decreased by 5 rupees. On that reason, my lord, petitioner made an application for the protection of the salary. And my lord, the authority concerned considered the protection and they increase the rupees 5. And thereafter, my lord, this was the continuous still the date of retirement. And my lord, after retirement, well, the authority concerned kindly, my lord, the reply to them.
Heard the submission of learned
kindly
advocates
appreciate-
representing both the parties. Next date we fixed on অনেক orders আছে। 26th of September for orders. Come early in the morning.
My lord, at that time, my lord, I will be out of station, my lord, for my medical health checkup. My lord, kindly fix any day from 15 to 19.
Every day there are many matters. Come on 14th of November. 14th of November for orders. Next. Acha. A claim application.
In this matter, Mr. HON'BLE is being appearing. He is in division bench in before court number 16. I'm saying for a short session.
Suppose 227, 228.
Is that yesterday's matter, my lord, wherein that premium check was
Yes, tell me the page numbers once and the exhibits.
my lord. First, I'll come to the deposition of OPW1, my lord. It is at page 28. It's between page 28 to 31.
No, that I know.
The my exhibits, insurance company's exhibits.
Yes.
My-
Your only point is, as you said, it's not on a very strong ground.
Yes.
Right? So you just tell me the exhibits. The notice when you had sent and the insurance policy, the premium, last premium to be paid, the date and all these.
The take that has been issued by the some other person. The story they have
some Bhagat or Bhagat.
Ashok Bhagat. So they did not touch the owner. The name is appearing that. Against that, no allegation, no notice, nothing.
Is it very important? Let her finish, then you will get your chance.
As far as it starts from there, the entire thing has been that is payment. Again, that also has come out.
Which observation is otherwise correct?
That's second. I'm sorry, 141 second.
I have one cross.
For what?
But Lordship, kindly come. The learned tribunal stateway denied to grant any future prospects. Page 146, paragraph, third paragraph. Page 146 of the judgment.
There was no loss of income.
And he was has been amputated. And also kindly come the page 146. So there is no question of proceeding further determining the loss of future earning capacity. But if the tribunal concludes that there is a permanent disability, then it proceed ascertain the to the extent after tribunal ascertain 146. The actual extent the permanent disability of the claimant based on medical.
Which page is he on?
146. Judgment inner page 13.
This must be a quote from another judgment. It is in within inverted comma.
146 page.
Yes, 145.
146, Lordship.
Come to 145.
Yes, Lordship, 145.
That has been quoted. He's reading that. Therefore, there is no dispute to the left hand of the hand to be.
Yes, Clement, that next paragraph had to be amputated. So, considering the all aspects, tribunal weighed evidence carefully and find the justice will be served if the functional disability 80% claimed by the claimant. So, she's declined that.
Declined?
Yes, no future process granted by the learned tribunal. So, you kindly see the next page 147.
No, but then functional disability has been assessed.
80% is disabled certificate is appearing from the 80%. One left hand is amputated. Seven. Another issue is that another issue. The learned tribunal after that assess the compensation by considering the monthly limit is 5,000 per month. The accident took place in the year of 2017. But one of the co-employer and the side of the employer has come before the learned tribunal. He has filed one income certificate that he used to pay rupees 13,500. But the learned tribunal not accepted that. Accordingly, come to a conclusion 5,000 per month is just and proper. Accordingly, assess the compensation accordingly. But that evidence is there. One of the side of the employer.
Which page?
Yes, Lordship, kindly come to page, Lordship, 26. Yes. And page 26. I have been duly summoned. The court closed the case. Presently, I am posted in the site charge of our company, namely Home Engineering Electors. I have duly authorized by our company, namely Home Engineering Electors, to depose this case.
You please read cross-examination.
Yes, Lordship, then cross-examination. I did not produce the attendance register of the company. There is a cross-examination. They cross.
Yes, please read.
Yes, I did not produce the register of our company to show that Vishwajit Das used to work at our company site supervisor. I did not produce the payroll register before the court, show their salary register. So I did not produce the appointment letter of Vishwajit Das. I cannot say the basics of.
You are very clear. What do you think? I am not on this page.
I lost you on the page.
If that be the case, why did you skip this statement? I did not that particular. I did not produce a payroll register before the court to show the salary of Vishwajit Das. At this moment, I have no document to show that Vishwajit Das used to draw rupees 13,500 per month from our company as his salary.
So at this stage, she is not having with the paper, but the document.
I did not produce appointment letter of Vishwajit Das before the court. I cannot say on the basis of which document the salary certificate was issued. I have no personal knowledge about the document which I produced before the court today.
But Lordship, what does it mean? It is meaning thereby that they are not the company not having with this document.
Every day, I have many.
Lordship, I leave it to your Lordship. Even then, I leave it to your Lordship. 2017, Lordship, kindly see. And Lordship, another plea is that Lordship kindly come to the judgment of the awarded. I leave it to your Lordship. And Lordship, the
the 4th of February. And this PWCC came and deposed that the victim was employed till 25th January. Fourth. I'll give the calculation after the.
No, no.
I'll give you. Read. Okay.
It's the 330. My lord. But you give
Item no. Responded. Much.
আর একটুখানি বকা
My lord, I am appearing for High Court administration also.
This for people of that 25th July. And that day I was sick. On admission, I was.
আপনি আছেন?
The matter was.
এদের এই জজ সাহেবের
Inspection. For my.
Would have, I appear for the private respondent in this matter. But normally, I would not have stood in the way of a matter being restored on a personal ground of a learned advocate, but for the deponent trying to put some aspersion on the court. Please come to there are two successive applications, item numbers 1 and 2. Both got dismissed on the same day, presumably at the same time. Please come to paragraph 3 of the first matter with paragraph 3 of the second matter. But so far as the learned advocate's absence is concerned, I have no comment submission to offer. That this was brought to the honorable court's notice. How could you bring this to the honorable court's notice if he was absent? Paragraph 3. WPO 173 of 2020. Please compare these two paragraphs. As to went out of Calcutta for the purpose of admission, document verification was started from 24th July of his son at the G.
I come across this every day. I come across it.
Rectify this mistake. It's a court of records after all.
At times. Take it unto fact.
I understood. But this,
I mean, of course, this is one of the instances.
But this probably gives an impression that the personal difficulty of my learned friend was brought to your lordship's kind notice and your lordship was pleased to turn down this prayer. This is not so.
Somebody passed by.
The order records that none appeared to represent either of the parties. That's the order. It says that when the colleague prayed for an accommodation.
Let us change this, sir.
Please hold.
Rectified further. Otherwise, it's an aspersion against the court.
So you are representing the High Court administration? No.
Sir,
Yes, why the respondent?
for the respondent number 6.
Fine. I have fresh of that one. Then fight tomorrow. Fight.
Same here in Behala.
This
The permanent residence is good, sir. But when the letter was filed and that time temporarily staying here in Behala. Temporarily staying here for the purpose of
Item number 3.
I will find the place.
yes, then you would fight.
Item number 3.
Yes. This petitioner is present, my lord.
The repetition before the honorable apex court from transferring of this repetition to the anchor court. By order dated 13th August 2025, the honorable apex court had been pleased to transfer the petition, present repetition from this honorable court to honorable court at Delhi Lords. This is the order I am calling. Not appearing for the duty to communicate your lordships. And it's the order, lordship.
The department has placed me.
Lordship.
I get to go out liberty to mention. Right?
Are you the petitioner?
Petitioner is present, my lord. Parag Sharma present.
Yes.
My lord, may I make some submission? I am thankful to the Honorable Court. The Honorable Supreme Court has transferred my petition. I am thankful for the cooperation of this Honorable Court during the time.
Sir, it will be transmitted. The case records will be transmitted. What of them new received? No, no. Oh, my God. আচ্ছা পার্ট থার্ড অ্যাসাইন কিছু থাকলে ওগুলো
Item number 203.
Yes, where is your senior?
My lord, Mr. Ghosh is not keeping well, my lord. He has joined court, my lord. He met with an accident, my lord. He has rejoined.
I saw him.
He has rejoined court, my lord, but he is not keeping well every day, my lord. He has not come to court today. But my lord, subject to your lordship's convenience, if the petitioner wants to start arguments, my lord, I'll take notes, my lord. Great.
I did not need to trouble the lordship very and how many application. There's a bit of order missing that needs to order.
This is under section 138 of the NIA. Those publication of both these no.
I am the one, my lord, who is authorized, my lord. I am the, my lord, the Dayanand Saraswati Maharaj, my lord, he had left behind a will way back in the year 1899. My lord, the entire right to publish the book is to me, my lord. This is his will, my lord.
Sir, this issue needs to be gone into. I have seen it.
Lord, if my lord is to put on insurance of someone, I need not trouble you, lord. My lord, I was on that. Otherwise, my lord, I'll place the facts. And my lord, on the face of it, I can show my lord and demonstrate, my lord.
Which is the impugned order which you have challenged?
Yes, my lord. Yes, my lord.
234.
End of February. My lord, there's an order of stay, my lord, which is passed by this one. Yes, 234, lord.
Record is put at phone.
The second of February. First order. No. Second of February. Today, complainant, namely, Anand, should examine the SPW on the basis of initial produced by the complainant, I find sufficient law. No application of mine, my lord, whatsoever.
Deposition was considered.
The order has to reflect. My lord, will kindly bear with me. The judgment, my lord, I will place, and a very recent judgment of Honorable Supreme Court. My lord, there is no, my lord, reasoning given. The complaint is.
No, reasoning is on the base. Yes, it might be very concise, but on the basis of initial deposition and the defamatory articles produced by the complainant. Now, this the deposition is on record.
Not available.
No.
LCR, possibly LCR has been called.
LCR has negated.
Almost similar points.
It is not simpliciter that, yes, it's very concise, but
almost can you just 2-3 paragraphs? The first judgment is reported in 1998 5 SCC 749. Lordship, take paragraph number 20.
sir, in 237, the PW1, he was examined under section 200 of the CRPC. His entire deposition is there in page number 237.
I bowed on you. The deposition is there, but the order does not reflect. Lordship, can you see what the order is?
Yes, on the basis of initial deposition and defamatory articles produced by the complainant. So,
or even a single complaint or an averment, my lord, as to who was the person who approached the complainant and lodged the complaint that yes, he has been defamed. There is no averment to that effect. No person's name. If lordship permits me, I can place the entirety of the complaint, my lord. If my lord, can you take paragraph 28 of this judgment, my lord?
no, sir, can you come to page 37, 237 once? The defamatory articles, which is the subject matter of this case, were printed in the month of August and September 2011 editions of the said magazine. These articles contain defamatory allegations against me. The said articles have defamed me and lowered my prestige in the minds of its readers. As a result, I got many phone calls from them. I wrote an article in reply to the allegations leveled against me, but the said article was not published in the magazine. I was mentally shattered on reading those defamatory articles and suffered a lot of trauma. All the allegations contain false imputations against me, and they have lowered my prestige in the minds of the readers of our magazine.
Two things, ma'am. Firstly, my lord, what are the defamatory articles? Nothing much in his deposit. What is defamation, my lord? I may say many things. Secondly, if lordship sees, I got many phone calls from them. Who? He should have named at least one person. Not a single person's name is there, my lord. My lord, this in my respectful submission, my lord, this has to be treated as complete non-application of mine on the part of the learned magistrate, my lord, while issuing summons. At least, my lord, then learned magistrate should have put questions, my lord, upon the complainant, my lord.
Okay, sir.
My lord, may I pray for one indulgence, my lord? Can I get a copy of the judgment which was relied upon, my lord?
I'd like to rely on three judgments, my lord. One is, my lord, 1998, volume 5 SCC, 749, my lord, paragraph 28, 30, and 31. If my lord kindly permits me, I'll just take my lord 5 minutes.
Sir, in any case, it is 3:30 today, and I have many orders to dictate also, sir. You just mentioned the paragraph, number of the paragraphs, I'll go through it.
28, 30, 31.
28?
30 and 31. 30 and 31. Lord, the another judgment, my lord, is reported in 2025 SCC online 209, my lord, headed by my lord, the Honorable Chief Justice.
Paragraph?
Paragraph number. Paragraph number 2.7.
3?
2.7. 3.7. 32, 33, 34, and 38.
32, 33?
And 38.
And 38.
The same proposition, my lord, that the order issuing summons, my lord, did not, my lord, was a reasoned order, my lord. The complaint itself needs to be set aside, and my lord, and the 482 has to be allowed. My lord, this is reported in 2025 SCC online. In the case of GM Laboratories, my lord, paragraph number 3.3, 3.5, 3.3, 3.5, 6 and 9.
Okay. When will he come next?
And your lordship fixes a date, my lord, I will inform you.
For the submission of the learned advocates representing the petitioner. Next date be fixed on 18th of November. You are not the amicus curiae to have been appointed. Then why are you giving your name?
And I have given my senior.
Next.
Should we take it back, my lord?
In this matter, I am appearing for the respondents. My learned friend is appearing for the appellant. On last occasion, your lordship says, given liberty to file a written notes of argument, I prepared the written notes of argument along with.
This is that matter pertaining to Purulia.
Yes, pertaining to Purulia. So many times, my lord, heard out this word, my lord. I prepared the written notes of argument, my lord, and chronologically date.
Next date file.
You were supposed to file it earlier.
Long before, my lord, long before your losses.
Just because they were.
Yes.
The matter appeared in the list, perhaps. The written notes filed by the learned advocate representing the. So you are for respondent number?
Respondent.
Respondent.
Respondents. Yes.
I think all 1 to 5.
1 to 5.
Respondent number.
No,
Yeah.
Respondent number 1 to
not
5.
contested before the.
Be kept on record. On the prayer of learned advocate representing the. You are the plaintiff appellant.
And the written notes of argument may be kept on record, my lord. On behalf of the respondents.
Next date be fixed on 13th of November.
13th of November.
As
a fixed
no
my lord.
further time.
But
will
no
be-
further. Yes, my lord. I am also requesting to my learned friend not to take any adjournment. 13th, my lord, November. Lift up.
No, along with your written notes, you do that. You will be filing the written notes. Along with that,
I have, along with my, I have annexed all the judgments passed by the honorable court, along with the written notes of argument, my lord. Deeply obliged.
next.
Firstly, on behalf of the respondent.
Where is the petitioner? He's not present.
That's been last occasion due to that the resolution I couldn't appear before Lordship also. I filed my affidavit opposition.
You're filing it today?
No, I have already filed.
Vice Secretary. আর একটা যে রেকর্ড আছে আর একটা রেকর্ড
CO 678 of 2020.
এটা কি পরেরটা এটা যেটা অ্যাসাইন হয়েছে
রেসপন্ডেন্ট ব্যাংক সাপ্লিমেন্টারি এফডিপি ফাইল করেছে।
কোন ডেট এর মধ্যে নেই দাঁড়িয়ে থাকুন কোনটা বলছি
তার ক্ষেত্রে আমি রিজয়েন্ডারও ফাইল করেছি। রিজয়েন্ডার
হ্যাঁ বলুন এটা থেকে কি বলতে চান
প্যারাগ্রাফ 2 থেকে 2-3 আমি এভাবে বলছি 4 থেকে শুরু করব। প্যারাগ্রাফ 4
বলুন
Paragraph 2. The petitioner has availed cash credit loan on 24/9/2003 এবং রোমান 3 স্টার হাউজিং লোন রুপিস 8 লাখ টাকা on 17/3/2005। তারপর লাস্টের আগের লাইন
the petitioner agreed to the terms and conditions of the sanction as stipulated in the said sanction letter.
না, মাঝখানে তো একটা টার্ম লোন আছে।
টার্ম লোন আছে, কিন্তু আমি এই দুটোকে আপনার সামনে হাইলাইট করতে চাই। 24/3/2009-তে 3 লাখ টাকা হচ্ছে ক্যাশ ক্রেডিট লোন, আর স্টার হাউজিং লোন হচ্ছে 8 লাখ টাকা 17/3/2005। এবার লাস্টের আগে the petitioner agreed to the terms and conditions of the sanction and stipulated in the said sanction letter by accepting the said by signing in the sanction letter as token of their acceptance. The copy of all sanction letters 24/9/2003, 17/3/2005, annexure এবং এটা হচ্ছে annexure B। তাহলে লর্ডশিপ annexure B টা একবার দেখুন, পেজ 30। কি বলতে চাই?
এটা ডেট কত? অ্যানেক্সার বি এর ডেট নেই?
annexure B এর কোনো ডেট নেই এখানে। এদিকে
14 নম্বর পাতায় আছে তো, 28 ডিসেম্বর 2007।
14 বেশ, এটা তো স্যাংশন লেখা নয়, এটা 32 নোটিশ। এখানে পুরো পরিষ্কার লেখা রয়েছে নোটিশ আন্ডার সেকশন 32, স্যাংশন লেটার 32। সেকেন্ড পয়েন্ট হচ্ছে মাই লর্ড, পেজ 25। চার্ট রয়েছে।
হ্যাঁ,
ব্যাংক এখানে কোর্টকে সবসময় বলছে আমাকে স্টার হাউজিং লোন দেওয়া হয়েছে, আর এখানে বলছে টার্ম লোন 8 লাখ টাকা। স্টার হাউজিং লোনের ক্ষেত্রে এবং সবচেয়ে বড় কথা 9 পয়েন্ট এফিডেভিটও ব্যাংক এই একই কথা বলছে। তারপরে পেজ 26-এ প্যারাগ্রাফ 4, অ্যামাউন্ট লোন টেকেন, পেজ 26, প্যারাগ্রাফ 4, অ্যামাউন্ট লোন টেকেন ₹8 লাখ টাকা, ডেট অফ স্যাংশন 17/3/2005, পারপাস ফর হুইচ লোন ইজ টেকেন ফর বিজনেস। এইচপিএল কখনো বিজনেস লোন নয়, এইচপিএল হাউস বিল্ডিং লোন, আমাকে বাড়ি কেনার জন্য লোন দেওয়া হয়েছে, এটা বিজনেসের জন্য দেওয়া হয়নি। এখানে ব্যাংক বারবার প্যারাগ্রাফ করে এখানে লেখা রয়েছে স্টার হাউজিং লোন। এখানে সেই হাউজিং লোনটা যখন 9 পয়েন্ট এফিডেভিট হচ্ছে ডিএম এর কাছে, সেটা হয়ে যাচ্ছে টার্ম লোন, আর এটা বিজনেস দেওয়া হয়েছে বিজনেস। এখানে হাউজিং লোনের কোনো প্রশ্নই নেই, এটা টার্ম।
এটা আপনি যে 25 নম্বর পাতায় যেটা দেখালেন, ওটা আপনি কি দেখালেন?
25 নম্বর পাতায় দেখালাম যে টার্ম লোন, এটা এটা ডিএম এর কাছে, ডিএম এর কাছে যে 9 পয়েন্ট এফিডেভিট করেছে, সে 25 এবং 26 দুটো পাতা।
না, এটা যে আপনাকে বাড়ি কেনার জন্য লোনটা দিয়েছে, সেটা কোথায় বলা আছে?
এই প্যারাগ্রাফ 4-এ স্টার হাউজিং লোন ₹8 লাখ টাকা, পেজ 4।
আচ্ছা, ঠিক আছে, এটা আপনি বলছেন। এবার 26 পাতায় আছে। তো এই 8 লাখ টাকাটার কথাই কি ওরা বলছে?
এক্স্যাক্টলি 8 লাখ টাকার কথাই। তার কারণ হচ্ছে মাই লর্ড, ভালো করে দেখুন 25 নম্বর পাতা, ইকুইটেবল মর্টগেজ, যেটা হচ্ছে, যেটা আমাকে এইচপিএল দেওয়া হয়েছিল, যেটা 11 mm ফিডার রোড, যে বাড়িটা আমি কিনেছিলাম একটা টিডি বাড়ি, সেটা হচ্ছে 11 mm ফিডার রোড। এখানে 8 লাখ টাকা যেটা স্যাংশন করেছে, যেটা 9,57,079 টাকা 44 পয়সা হয়েছে,
সেটা দেখুন, এটা হচ্ছে 11 ফিডার রোড, কলকাতা 57, যেটা ব্যাংক স্যাংশন করেছিল হচ্ছে 17/3/2005। এখানে প্যারাগ্রাফ 4 অনুযায়ী সবচেয়ে মারাত্মক ঘটনা যেটা, তার তলায় রয়েছে এক্সটেনশন অফ ইকুইটেবল মর্টগেজ। এক্সটেনশন অফ ইকুইটেবল মর্টগেজ, সিসি। আপনি এতে দেখুন 26 নম্বর পাতায় আরো পরিষ্কার ভাবে বুঝতে হবে। এখানে ডেসক্রিপশন অফ সিকিউরড অ্যাসেট দিয়েছে 7 নম্বর প্যারাগ্রাফে। 7 নম্বর প্যারাগ্রাফে ডেসক্রিপশন অফ সিকিউরড অ্যাসেট, এখানে বলছে 11 ফিডার রোড। প্রথম এক্সটেনশন অফ ইকুইটেবল মর্টগেজ 11 ফিডার রোডের যে এই অনুযায়ী প্যারাগ্রাফ 4 অনুযায়ী স্যাংশন ডেট হচ্ছে 17/3/2005। তারপর এক্সটেনশন অফ মানে তারপর এক্সটেনশন হয়েছিল কোনটা, সেটা স্যাংশন ডেট হচ্ছে 24/9/2003। প্যারাগ্রাফ 4 দেখুন,
কোথাকার প্যারাগ্রাফ 4?
এই সাপ্লিমেন্টারি এফিডেভিট প্যারাগ্রাফ 4। Petitioner has availed cash credit loan limit 3 লাখ টাকা on 24/9/2003। এখানে যেটা এক্সটেনশন অফ বলছে সেটার জন্য যে ফ্যাক্টর দুটো প্রপার্টি মর্টগেজ করেছিল, দুটো প্রপার্টির মধ্যে 11 ফিডার রোডটাকে, যেটা আমি জেনেছি হাউস বিল্ডিং লোন হিসেবে সমস্ত কোর্টে এখানে লেখা রয়েছে হাউস বিল্ডিং লোন প্যারাগ্রাফ 4 অনুযায়ী, সেটা জিএম এর অফিসে যাচ্ছে টার্ম লোন হিসেবে, বিজনেস হিসেবে দেখানো হচ্ছে। প্রথম কথা, এটা স্যাংশন হচ্ছে 17/3/2005। 5 নম্বর প্যারাগ্রাফ অনুযায়ী 26 পাতা, 5 নম্বর প্যারাগ্রাফের 26 পাতা 5 নম্বর প্যারাগ্রাফ, ডেট অফ স্যাংশন 17/3/2005। মানে এই 11 ফিডার রোডটা এখানেও অ্যাজ পার প্যারাগ্রাফ 4 সেখানে পরিষ্কার লেখা রয়েছে।
ঠিক আছে, তারপরে
17/3/2005 মানে এক্সটেনশন অফ লোন হয়ে গেল 24/9/2003। 24/9/2003 যেটা এক্সটেনশন হচ্ছে
সেটা কোথায় পাবো? 24/9/2003
একদম 25 এবং 26। 24/9/2003 এই তো, সেটা আপনি প্রথমেই প্যারাগ্রাফ পড়েই লেখা রয়েছে, একদম প্রথম লাইনটাই।
আপনি তো পুরো ব্যাপারটা ভালো করে জানেন, জানেন তো? আপনি এক্সপেক্ট করতে পারেন না যে আমি সব জানি।
আমি না এরপর ভুলে গেছি, আস্তে আস্তে Petitioner has added cash credit 4 নম্বর প্যারাগ্রাফে ফার্স্ট পয়েন্ট 1 ক্যাশ ক্রেডিট লোন লিমিট, এটা প্রথম বিষয়।
হ্যাঁ, তো এইটার এগেইনস্টে আপনার থেকে তো কিছু সিকিউরিটি নিয়েছিল বা মর্টগেজ নিয়েছিল, সেটা কোনটা?
সেটা হচ্ছে এক্সটেনশন, যেটা 25 নম্বর পাতায় 2 নম্বর, এই যে 1 নম্বর ইকুইটেবল মর্টগেজ, 2 নম্বর মর্টগেজ 26 নম্বর পাতা।
তো এই যে দুটো মর্টগেজ রেখেছে, একটা বলছে equitable mortgage of more or less 2 kata 6 chhataks 26 square feet land with 2-storied building at premises number feeder road। আচ্ছা, এইটা 8 লাখ টাকাটার জন্য আপনার ওই স্টার হাউসিং লোন। আচ্ছা, পরেরটা কি? এক্সটেনশন অফ ইকুইটেবল মর্টগেজ। আপনি আগে পড়ুন ওর, এটা কিসের জন্য?
এটা কুলেন্ট টিম, এই যে লেখা রয়েছে দেখুন, অ্যাকাউন্ট অফ অরিজিনাল ক্রিয়েটেড অ্যাকাউন্ট অফ মেসার্স কুলেন্ট টিম,
মানে যার এগেইনস্টে আপনি আগে 3 লাখ টাকা নিয়েছেন। তারপর এবার কি হলো?
3 লাখ টাকা দিয়ে ব্যবসা শুরু, তারপর ভালো ব্যবসা করার জন্য ওরা আমাকে ফার্দার হাউসিং লোন, কিন্তু
8 লাখ টাকা। আর তার এগেইনস্টে আপনার ওই কি ফিডার
রোডের প্রপার্টিটা মর্টগেজ।
হ্যাঁ, তারপর
ঠিক আছে, কিন্তু এখানে হয়ে গেল, এখানে মর্টগেজটা দেখালো প্রথমে, যেটা 5/7 মানে 26 নম্বর পাতায় দেখুন, এই একই ডেসক্রিপশন অফ সিকিউরড অ্যাসেট 1 নম্বর ইকুইটেবল, যেটা স্যাংশন হয়েছে 17/3/2005। এক্সটেনশন অফ, তার মানে এক্সটেনশন হয়েছে, তো এক্সটেনশন হয়েছে যে লোনটা, সেটা ডেট অফ স্যাংশন হচ্ছে 24/9/2003। মানে
না, ওরা এখানে কি কি আপনার থেকে নিয়েছে সেটা লিখেছে, ডিসক্রিপশন অফ সিকিউরড অ্যাসেটস সেটা লিখেছে। আপনি যেটা বলতে পারেন সেটা হচ্ছে, যদি ওই 8 লাখ টাকাই ব্যাপারটা হয়, তাহলে ওটা আপনার হাউস বিল্ডিং লোনের জায়গায় ওরা লিখেছে ফর বিজনেস। হ্যাঁ, এবার বলুন।
এবার এবার আসছি করছি 4, 5, 6 হয়ে গেছে। এবার আসছি আচ্ছা এখানে ডেট অফ মানে এখানে আমার একটাই বক্তব্য। 4 নম্বর প্যারাগ্রাফে এবার আমি সাপ্লিমেন্টারি এই যে রিজয়েন্ডারটা দিয়েছি এইটা, সেখানে আমি একবার 4 নম্বর প্যারাগ্রাফটা আমি আপনার সামনে একবার পড়ে নিচ্ছি। সাবমিটেড রিজয়েন্ডার, হ্যাঁ আমার রিজয়েন্ডার এইখানে আছে কোথায়? 8/4/2025।
আচ্ছা আপনি আপনার ওই ওদের ওই যেটা দেখাচ্ছিলেন সাপ্লিমেন্টারি অ্যাফিডেভিট যে 4 নম্বর প্যারাগ্রাফটা পড়লেন না, একবার 5 নম্বর প্যারাগ্রাফে আসুন।
Construction of residential hub
at a concessional rate of interest, whereas after construction the petitioners had used the said residential house for ladies hostel for commercial purpose, earning huge amount of money, but failed and neglected to pay the interest and EMI on cash credit, as well as term housing loan account. The respondent, bank number 2, had followed up with the petitioners to regularize the accounts, but the petitioner did not pay any heed to the request on advice of the respondent number 2, and accordingly the said loan account as declared classified as NPA on 39/2007 by strictly adhering to the prudential norms and guidelines of the Reserve Bank of India in this regard. তো এবার এটা কি হতে পারে যে আপনি বাড়িটা তো বানালেন, বাড়ি বানাবেন বলে লোনও নিয়েছেন, তারপরে সেটাকে কমার্শিয়াল পারপাসে ইউজ করছেন বলেই ওরা ওখানে বিজনেস লিখেছে? এটা হতে পারে না।
কারণ আমি বাড়িটা কিনেছিলাম 17 একটা রেডি বাড়ি আমি কিনেছিলাম আমি, আর এই যে লেডিস হোস্টেলটা তৈরি করি তার 5 বছর বাদ, মানে 2011।
তো লোনটা আপনি ব্যবসার জন্য নেননি?
না, আমি এইচপিএল হিসেবেই নিয়েছি এবং এইচপিএল হিসেবে আমি বাড়িটা কিনেছিলাম, এখন রেডি বাড়ি, আমি কোনো কনস্ট্রাকশন করিনি।
ঠিক আছে, কি দেখাতে চাইছেন?
মানে আমি জাস্ট
রিজয়েন্ডার
আর্গুমেন্ট এবং দেখো হ্যাঁ রিটেন নোটস অফ লাস্ট দিনে আমি রিটেন নোটস অফ আর্গুমেন্ট এবং সাপ্লিমেন্টারি এফিডেভিট এইটা।
আর কি বক্তব্য আছে আপনার?
আচ্ছা বলে নি আলাদা করে পড়ে। আচ্ছা দ্বিতীয় হচ্ছে মাইলর 7 নম্বর প্যারাগ্রাফ, আগে দেখিয়ে নিই তারপর আমি আপনাকে পড়ে।
আগে পরে বলবে, অত কথা বলার জায়গা নেই, আপনি যা বলবেন তাড়াতাড়ি বলুন ঠিকঠাক। দেখি রিজয়েন্ডারের
4 নম্বর প্যারাগ্রাফ।
বলুন।
পেজ 6 4 নম্বর। না স্যার 4 নম্বর।
আপনি তো এই নোটিশের বাইরে বেরোতেই পাচ্ছেন না, মানে গত 4 দিন ধরে আপনি ওই নোটিশেই আটকে আছেন, অত তো বোঝা গেল।
Respondent number 1 issue the statutory demand notice section 30 Surfacing Act।
ওরা ভুল করেছে, ওরা পারমিশন নেয়নি, ওর ডিএম এর থেকে কিছু নেয়নি, সব বোঝা গেল। এবার তারপরে কি হলো?
এটা দেখুন,
আমি দেখেছি তো, এটা তো আপনি আমায় দেখিয়েছেন, আগেও দেখিয়েছেন, যে ওরা ডিএম এর থেকে কোনো ইনফরমেশন ডিএম কে না দিয়ে একটা এডিএম এর চিঠি দেখিয়েছিলেন না, যেটা ওরা পরে দিল, যেটা আগে ছিল না, সেটা দেখিয়েছিলেন তো? হ্যাঁ, তো সেইগুলোর থেকে এবার একটু আগে যাই আমরা, ওগুলো তো হয়ে গেছে অনেক আগে, কতবার দেখবো, অত সময় নেই তো।
ঠিক আছে ঠিক আছে।
হ্যাঁ, আপনি 4 বার
Petitioner did not pay any amount or made an presentation under 13(3)(a) Surfacing Act 2002. But the petitioner has made OTS offer which the respondent bank rejected with a request into the same which to be accepted by the respondent. আবার যদি 32 যদি না হয় তাহলে ব্যাংক 33 দিবে। প্রথম প্রশ্ন আসবে সেই ক্ষেত্রে সিও পিটিশনে আমি একটা আপনারা লিখতে হবে না, আমি একটা প্যারাগ্রাফ পড়ছি, এটা অর্ডার পেজ 24 এ রয়েছে অর্ডারটা অনারেবল ডিআরডি দিয়েছে, এটা হচ্ছে পেজ 24 এ সিও তে রয়েছে, এখানে অর্ডারটা লেখা হয়নি। অ্যাডমিটেডলি সিও পিটিশনের পেজ 24 ইন সিও পিটিশন paragraph 4. Admittedly, petition notice was issued 14/2/2015 and essay was filed 24/3/2015. Thus, it is obvious essay was filed within the limitation period of 45 days. In essay, there was clear allegation at paragraph 5.23 the representation under section 3A of Service Act was not responded further that the petition notice was not properly published in newspaper. এটা এখানে বলা হচ্ছে শুধুমাত্র আমার কাউন্সিল যে করেছিলেন তিনি কোর্টকে কনভিন্স করতে পেরেছিলেন যে 33 এ ব্যাংক দেয় কিন্তু মাই লর্ড এই যে নম্বর প্যারাগ্রাফ রেসপন্ডেন্ট নাম্বার 1 ইস্যু
কোথাকার নম্বর
এটা হচ্ছে সাপ্লিমেন্টারি রেসপন্ডেন্ট নাম্বার
বলুন
Respondent number 1 issued a notice under section 34 of the Service Act 2019 Act 2003 by way of posting, pasting and publishing in newspaper 17 Act 2012 সেই আবার সেই প্রশ্নটাই আসবে 32 কে না 34 সেই ক্ষেত্রে মাই লর্ড একবার পেজ 24 টা একবার পেজ একবার দেখতেই হয়
কোথাকার 25 নম্বর
সাপ্লিমেন্টারি 25 24 এই ঘুরে ফিরেছি এক জায়গাতেই আছে মাই লর্ড যে
আপনি তো তার থেকে এগোচ্ছেন না
এবার পরেটাই যাচ্ছি একবার দেখি যে 28/12/2027 যে মাই লর্ড যে ব্যাংক 13 করেছে কিন্তু সাপ্লিমেন্টারি 14 নম্বর প্যারাগ্রাফে বলছে 31/10/2011 তে 13 করা হয়েছে মানে ইয়ারের কাছে এটা কিন্তু অ্যাকচুয়ালি মাই লর্ড ব্যাংক 13 বা যা কিছু করেছে সেটা আমি যে আরটিআই করেছিলাম 9 পয়েন্ট এভিডেন্স যে করেছে সেইখান থেকে জানা যাচ্ছে এই টোটাল জিনিসটা করেছে এর পেজ করেছে যে লোনটা নিয়েছিলাম এগুলো সবকিছু ওর ক্ষেত্রে করেছি ওখান থেকে এটাকে কপি করে এখানে বসিয়ে দেওয়া হচ্ছে কারণ হচ্ছে পেজ 27 হচ্ছে এই যে রিজয়েন্ডার যেটা দিয়েছি এখানেই আমি 9 পয়েন্ট এভিডেন্স আরটিআই এবং 9 পয়েন্ট এভিডেন্স সবকিছু আমি অ্যানেক্স করেছি পেজ 18 থেকে আমি যে টিএমের কাছে আরটিআই করেছিলাম আরটিআই এর 9 পয়েন্ট এভিডেন্স কথা এবং ছিলেন যে পয়েন্ট নাম্বার 1 ইয়েস এবং ওখানে আমি
এটা তো আপনি আমার আগে দেখিয়েছিলেন
এইখানে 9 পয়েন্ট এভিডেন্স যেটা করেছে অ্যাকচুয়ালি পেজ 28 এর পেজ 28 দেখতে পাই না তাহলে বুঝতে পারবে যে কুল্যান্ট পেমেন্ট অ্যাকচুয়ালি কুল্যান্ট পেমেন্ট এটা করেছে যা কিছু সবকিছু কুল্যান্ট পেমেন্ট এটাকে ওখানে কপি পেস্ট করা হয়েছে অ্যাকচুয়ালি এখানে কোনো ব্যাংক
ওরা তো দুখানা করেছে আপনার দুটো প্রসেস করেছে তো হ্যাঁ তো ওরা যদি কপি পেস্ট করে তাহলে আপনার সমস্যা কোথায়
তাহলে 28 করে 42 সাথে তো 32 নেই তার মানে আমার কাছে 11 mm ফিটার উপর 32 তো হয়নি 11 mm ফিটার উপর
হ্যাঁ, তো যখন এখানেও হয়নি সেখানেও হয়নি।
না এখানে হয়েছে এখানে তো ব্যাংক বলছে
হুম।
আমি 32 করেছি এখানে আপনি 9.8 mm এর ব্যাংক পরিষ্কার বলছি প্যারাগ্রাফ 14
তো সেটা আপনি মেনে নিচ্ছেন? তো সেটাই তো আমি আপনাকে বলছি যে অ্যাকর্ডিং আপনার মতে দুটোর একটাতেও 13.2 করেনি, তাহলে এবার 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 এগোন।
এবার হচ্ছে 13.2 করেনি 13.4 করে।
হ্যাঁ বাস, তারপর
এবার আসছে ম্যাডাম সেকশন 40 প্যারাগ্রাফ 11
কোথাকার?
প্যারাগ্রাফ 11 Respondent number 1 file an application under section 14 for the learning achievement state 24 Pargana North and after considering the fact and circumstances of the case and also document produced by the respondent number 1 learned additional district magistrate general issued the order on 2014 the copy of the section 14 application along with the order annexure E. Section 8
এটা তো এক্ষুনি আপনি আমায় দেখালেন। না না, এক্ষুনি একটা দেখালেন না এরকম এডিএম এর?
হ্যাঁ, এটা হচ্ছে এডিএম এর 9.8 যেটা করেছি সেটা হচ্ছে আমার বিজয়।
হ্যাঁ, তো সেটা তো পেয়েছেন না, কি জিনিস তো? হ্যাঁ,
এটা হচ্ছে শুধুমাত্র ব্যাংক দিয়েছে 11 mm ফিটার রোডে, কিন্তু আমি ওখান থেকে স্টুডেন্ট টিমের যে 5/1 এর উপর যেটা হয়েছিল সেইটাও আমি ওখান থেকে পেয়ে গেছি, তার জন্য অরিজিনালিটিটা আমি দিতে পারছি।
ঠিক আছে, এরপর
হচ্ছে মাইনার এখানেই তো এখানে মাইনার 19/2/2014 তে তখন অর্ডার ইস্যু করেছিল, কিন্তু বাড়ি তখন হচ্ছে 1 বছর 14/2/2000। ঠিক আছে, তখন আমি এখানে
এই 1 বছরের মধ্যে আপনি কোনো অ্যামাউন্ট রিপে করেননি?
আমি কিছু করিনি, কিন্তু আমি এটা আর্গুমেন্টে টেক্সটাইল ভার্সেস অথরাইজড অফিসার ব্যাংক অফ ইন্ডিয়া স্টেট ব্যাংক অফ ইন্ডিয়া তার একটা সাইটেশন দিয়েছি, অর্ডার দিয়েছি, সেটাতে বলা হচ্ছে যে 6 মাসের বেশি গেম অর্ডার ভ্যালিড থাকে, কিন্তু এটা অনেকদিন আগেকার ঘটনা, এটা 2025 এর হতেই পারে। ঠিক এখানে সবচেয়ে মারাত্মক জিনিস হচ্ছে এখানে দেখুন মেমো নাম্বার হচ্ছে 2213 তার তলায় রয়েছে তার হচ্ছে কপি ফরওয়ার্ড ফর দা ইনফরমেশন এন্ড টেকিং অ্যাকশন টু দা ওই পেজ 3 সাপ্লিমেন্টারি copy forward for information and taking action to the police commissioner as per Service Act section 14 police commissioner কোনো authority নেই, police commissioner DM এর subordinate নয়, এর সাধারণত তার authorized officer কে বলবে যে এই প্রপার্টিটা ব্যাংকের লিগ্যাল পজিশন নিয়ে ব্যাংকের হাতে তুলে দাও, তার জন্য পুলিশ অ্যাসিস্ট্যান্স আছে। কিন্তু এই ক্ষেত্রে সবচেয়ে মারাত্মক ঘটনা অথরাইজড অফিসার, এখানে ব্যাংক তার অথরাইজড অফিসারের নাম এটা হবে ডিএম এর অথরাইজড অফিসার। দেখুন 2 নম্বর অথরাইজড অফিসার ব্যাংকের অথরাইজড অফিসার। আচ্ছা, তারপরে হচ্ছে আরেকটা মারাত্মক জিনিস 3 নম্বর, এখানে প্রথমেই লেখা হচ্ছে এন্ড টেকিং অ্যাকশন টু দা, টেকিং অ্যাকশন দেওয়া হয়েছে, নিচে বলেছে 5/1 ডিগ্রি রেজিস্টার্ড কলকাতা 90 the jurisdiction মহানগর কি ব্যাংক সেখানে 11 mm ফিটার কি এর হচ্ছে বেলগড়িয়া কি, তাহলে গিয়ে অর্ডারটাই তো ফেক। যেটা বোঝা যাচ্ছে কি করে এই 9.8 থেকে যেটা ফেক কোন দিক এই কোন দিক থেকে দেখুন শুধু এর শুধু মেনু নাম্বারটা চেঞ্জ হচ্ছে আর বাকি সব ঠিক। মেনু নাম্বার 222 আর এটা হচ্ছে 221 যদি ধরে নেওয়া যায় ব্যাংক এই অর্ডারটা দিয়েছে, ধরে নেওয়া যায়, তাহলে বাড়ি দখল করতে বলতে তো 5/1 দিয়েছে রেজিস্ট্রি, এখানে তো লেখা রয়েছে, এখানে কোথাও 11 ফিটার লেখা নেই। হ্যাঁ, পুলিশ সবাই চলে গেল, কত পুলিশ নিয়ে চলে গেল 11 ফিটার করতে হবে। ঠিক আছে, তাহলে এই ডিএম অর্ডার থেকে শুরু করে এই সমস্ত 9 পয়েন্ট এভিডেভিট থেকে শুরু করে এবং সবকিছু টোটালটাই ফেব্রিকেট, ব্যাংক এটা কখনো করেনি। এবার সবচেয়ে বড় কথা মাইলর, এরপর ব্যাংক প্যারাগ্রাফ 12 সাপ্লিমেন্টারি ব্যাংক নিজে অ্যাডমিট করছে ব্যাংক একবার দেখুন।
কোথায় বললো?
তার আগে বলে নি মাইলর, তাহলে এখান থেকে এতটা জিনিসের উপর একটা জিনিস মাইলর প্রমাণ হচ্ছে যে ব্যাংক 13 করেনি, 13 যখন করেনি 33 আর 34 করতে সুযোগ হচ্ছে না, ডিএম অর্ডারও আসছে না। তারপর যখন ডিএম অর্ডার বাড়ি দখল করতে গেল, ডিএম এর অর্ডার রয়েছে 5/1 ইনস্ট্যান্ডার্ড উপর, ব্যাংক বাড়ি দখল করছে 11 ফিটার। তার আগে টার্ম লোন স্যাংশন সবকিছু টার্ম লোনের সবকিছু হয়ে গেল, যেটা দিয়েছে এই তো এদিকে গেল মাইলর। এতদিন অব্দি এই কোর্টের প্রথম 14/2/2015 বাড়ি দখল করার পর থেকে আজকে এসে প্রথম সবাই আমরা জানতে পারছি যে ব্যাংক এইসব জিনিসগুলো করেছিল, এর আগে এতদিন পর্যন্ত প্রডিউসই করে।
ঠিক আছে, এবার যা করেছে বলুন।
এবার শুনুন, petitioner had filed an application under section 71 of Servicing Act 2002 in the year of 2002, being essay number 142 of 2002 for seeking certain relief. A copy of the essay annexure 8 annexure 8 of পরের পাতায় মাইনর বলুন, it is pertinent to mention here that the petitioner have forged the document being essay number 40.
পিটিশনার কে? তো বলছে আপনি ফর্জ করেছেন।
আবার আমিই দৌড়ে বেড়াচ্ছি যে আমার চলে গেছে, তাহলে কেন ব্যাংক তখন প্রথম দিন বলেনি ফর্জ হয়েছে, আগে থেকে মানে যাই হোক
তারপর পড়ুন।
এবার মাইলর আস পড়ে Filed by the appeal reporter, the honorable head Calcutta, which evident from the document and from the জিনিসটা আমি বুঝতে পারিনি, তাই আমি এটা লিখতে যাচ্ছি।
তাহলে আপনি না বুঝলে কি করে চলবে?
না, কিন্তু আমি ফ্যাক্টটা আপনাকে দেখাবো। এবার
মানে এই কথা বলেছে কি?
না, এই জায়গাটা তো আলো পাবেন, বুঝতে পারছেন?
বুঝতে পারছেন না?
কিন্তু অরিজিনাল ফ্যাক্টটা কি সেটা আমি আপনাকে।
ঠিক আছে, সেটা আবার পরের দিন শুনবো। ঠিক আছে, ওটা পরের দিন শুনবো, আজকে তো অনেকক্ষণ আপনাকে সময় দিন। আপনি আমাকে মুখস্থ করিয়ে দিয়েছেন, বুঝেছেন?
For 1 minute, Lordship.
Sir, on the next date. Okay.
Lordship, I am now out of town from 31st to 4th.
31st to?
31st of this month to 4th of September.
Okay.
Lordship, he has filed some complaint before the learned secretary to Honorable High Court that he has filed 2 complaints before learned secretary. No. I'll produce how he has abused the court. No. He's abusing the court. He's also. I cannot use that word also here. I'll not placing. Yeah, no. Lordship, I'll show one letter.
Sir,
you will clearly observe that since he's appearing person.
People waiting, sir.
I'll show all these things. See how he has forged the documents. How to.
Okay, when your turn comes, sir, you will be given equal opportunity.
Against the PO contempt application.
Submission
against
of the
chairperson
petitioner
to contempt application.
in
To the High Court
person.
judge also.
All are dismissed.
Sir, he had তার মানেই নয় যে আপনি এই ধরনের ব্যবহার The learned advocate representing the respondent bank is present. Next date, it's on 18th of September.
18 September. আপনার ওপর রাবুল আসিফ ব্যাংক তাকে দেওয়ার রিটার্ন করতে জলদি করে দেবেন।
আগে মিডিয়েশনটা ডেকে দিন ধন্যবাদ। Somebody will start feeling sick, so it's better that you people be there. Conveniently feel sick and convenient. What does he mean? Ashun, why did you leave yesterday and day before yesterday? Huh? You told her that I'm leaving.
I'm feeling unwell. You please inform.
Anyway, ওই অর্ডারটা করা
আমি
আছে। এই 281 is his matter? Same order. 281?
281.
Okay. 282?
22 টা বলুন।
Who is there?
The other
Miss Paul,
secretary-
are you there? Who is for the insurance company? Who is the insurance company? আরে রেকর্ডটা কোথায়?
282.
Which is the insurance company, Mr. Boni? New India Assurance.
Somebody would appear tomorrow. My lord will kindly make it. Only this one. Someone must be there. Someone must. Or my lord will refer it. Let them. My lord will.
283? Same order. 284? 284? Your matter?
Yes, it was.
অর্ডারটা করে তো দিন তারপরে madam you keep track of this matter and you please contact the registrar of the mediation committee. Okay, next. 285? Miss, where is Miss? 285, okay, done. 286?
286, it's a dismissal case. So I was thinking.
Next, 287. 287. 288. 289 same. 290 same. 291 same. Bas. Acha, you had something to mention?
199.
You are representing the claimant respondent? Acha. A record to part karo, you wait for some time. Yes, you had something?
30, my lord.
230.
My lord, 30. Another heading forward, my lord. Hearing.
You are the respondent claimant?
Claimant, my lord. Mr. Singh is the my lord, appellant, my lord.
Okay. Let's see, we'll go to that. Yeah, wait, forward is 224 onwards.
I'm for the respondent insurance company.
You tell me the. Did she file any cross objection?
No.
I mean, cross appeal?
No.
32. Copy of the. And no objection has been raised by the opinion marking the same in the postmortem is in which page? Postmortem is in which page?
It's 51.
51. Show me the charge sheet. Okay. Hmm. Eyewitness is in which page? Which page? No, show me the observation of the tribunal.
Page 32.
Wait. Ashun.
There is no. Lordship, one thing, there is no valid driving license. That OPW1, page 26, 27, he has deposed. PW1 has stated 7,300 instead of 7,000.
7,300. What is 7,300?
Yesterday, my lord was kind enough to grant me time. May I kindly see the judgment of the Honorable Apex Court, my paragraph 19.
But this is not applicable to this case. You have a copy? In order to curb, you have a copy of this?
No, that judgment I have.
Now, in order to curb this widespread mischief of getting insurance policies after the accidents.
My lord.
It is absolutely imperative to clearly hold that the effectiveness of the insurance policy would start from the time and the date specifically incorporated in the policy and not from an earlier point of time, right? Now you see the policy itself mentioned the date of acceptance.
Oh, but it's effectiveness.
23rd or something it's written.
Kindly sees the
23rd of April.
But that is
Which is the page?
Page 33 of the paper book.
Yes. So it is not something that the policy had been, obtained after the date of the accident manipulatively.
The policy starts from 24th, my lord.
Yes.
24th of April,
This
time specified.
has a different intent altogether.
Now, my lord.
Now see, this date has not been provided by somebody else. It's by the insurance company itself.
That the policy starts from.
Yes.
But now another thing, my lord, as a officer of the court, my lord, I should rely another judgment. It goes against me, my lord.
Then
that is 2024 judgment.
You thought you can go away.
No, I was candid, my lord. I should. It was a.
You thought you will show.
No, this was a. This judgment. No, but kindly reside that judgment, and this is the latest judgment. Who has reside this judgment and directed that payment should be made.
You were taking chance. You thought this will not be dealt with in its proper perspective.
Kindly.
Now when you're caught, you are giving me this.
This was the latest judgment of 2024. That was yesterday. I told my. This is against me, my lord. So, but this has dealt with another thing, my lord. This is a case under 163A. My learned friend has not preferred any cross objection. In the calculation portion, the learned court below has given loss of leadership consortium as 80,000, funeral expenses 15,000.
163A or 166?
163A. 160. That will be 4,500. That is 95,000 has been granted. If my lord kindly.
This again is another way. You will get that comprehensive one. When did the accident occur?
Accident occurred not in 2017.
Show me the.
On 23rd of April 2017.
No.
Right.
5 July 2017. Kindly see the judgment, my lord, page 11.
No, what is it?
No. ওটা না, আপনি এটাতে আসুন। 5th July 2017.
But you have not preferred any cross appeal.
They have not preferred. That's some benefit.
You are not on the quantum.
No, I have in my grounds there are point.
What have you said?
Kindly see, my lord.
Where are your grounds?
Kindly see page 19, fifth ground. There is a
Not an accident occurred, my lord.
Whatever it is there, if you mark on this, then this 95,000 if it goes, then what remains?
But these benefit insurance. Kindly, my lord. But I am not on that point. That I obtained that order. Actually, why I was about to place that. That's been my lord.
You were not above. Yes.
No, but these judgment, 2007 judgment was there in these matters.
The accident, the accident occurred, my lord, before the amendment, 23rd of April 2017. The amendment came into effect, my lord, 22nd of May 17. 18. So after the amendment came into force, my lord, the 5 lakhs can be granted by a lawsuit, my lord, by implication of law.
Can you just find out the paragraphs? Need the
This is a dismissal case, Lordship.
Yes, 27, 28 last, 22, 29. So 227, 228. হয়ে গেছে? তাই? আচ্ছা, ঠিক আছে। 229. ঠিক আছে, এটা আগে হয়ে যাক।
My appeal. My appeal for enhancement of the award. I have taken 4 points. Number on the income, number to future prospect, and not multiplier should be 18. And in my 3 points. So far as the income is concerned, on the deceased, income tax certificate was produced. Income return.
What did the tribunal assess?
Can you have a look to the Lord award first? To the evidence. Page 18.
Page?
18. Page 18 evidence, my lord. Evidence of Brato Rani Ghosh, the claimant. A claimant. I have filed the photocopy of income tax return of my son, Abhijit Ghosh, now deceased, for the assessment year 2015-16 and 14-15. This is a series document comprising of 4 separate sheets and been marked as X for identification.
Anybody from the income tax department?
They did not come. Even not after just immediately after the close of the evidence, no time was given to call for them further. And within the gap of Lord, within gap of
which page?
Within gap of
16, 14, 15, which page?
52, 52. 50 to 54.
52. My last one, last page, my lord. Last 2 pages. Not I have so included not the done. It is marked.
You are claiming on the basis of this document? Achha.
Demanding it. Lawsuit demanded.
Has not been exhibited.
Not exhibited, not signed.
Not signed.
Not dated.
Yes, no.
Sign কোথায়? Dated.
File for the assessment here.
14, 15.
14, 14. Krishnagar.
Done. File for the This from 2000 as well as 2000. Translation piece about
My lord, it's the insurance appeal. My lord, I had come up with your lordship on the point of contributory negligence, my lord. The victim, while driving a motorcycle, collided with another motorcycle head-on. My lord, I am the insurance company of the other motorcycle, and my lord, entire liability has been, my lord, put upon my client, my lord, the appellant before your lordship. An award of 36 lakhs odd was passed in principle. That is 36 lakhs, 26,434 principal. Lord, with interest 6%, it has been secured before your lordship. Lord, I have come up before your lordship, Lord, on the ground that since it was a head-on collision, Lord, the liability of the person who was driving the motorcycle on this side, my lord, should also be should have been taken to a certain extent. But, my lord, this appeal, my lord, I have put in this for orders, my lord, my requisite has come up because, my lord, the eyewitness and the charge sheet is absolutely against, my lord, my kind, the other motorcycle. My lord, charge sheet is at page number, my lord, 34, if I can show it to your lordship.
Page number?
3434. My lord, it starts, my lord, sorry, my lord, page 17, my lord, it starts. My lord, I'm inviting a lordship to page number 20, 20, my lord, I'm sorry, my lord.
Yes.
My lord, 17 it starts, my lord, at 20, my lord, the last but one paragraph under section, my lord, so I'm submitting charge sheet, my lord, in the middle, if my lord kindly comes to
Yes.
page 20. So I'm submitting charge sheet in this case with is charge sheet number so and so against accused rider Nepal Chandra Das, so and so. My lord, my vehicle, my lord, is being driven by Nepal Chandra Das, the offending motorcycle, if I can say so, my lord. Being number
Produce records and circumstantial evidence of prima facie charge such and such, having been well proved against accused rider Nepal Chandra Das.
Lordship, my lord, Nepal Chandra Das is the driver or the rider of the offending motorcycle against whom, my lord, the award has been passed, insured by my client.
Okay.
And, my lord, as far as the eyewitness is concerned, if my lord can kindly come, my lord, to page number 20, page number 23, my lord. Paragraph 3. This is the eyewitness, my lord.
Now, what about cross?
My lord, cross, my lord, my learned friend prepared the paper book. He did not get all the documents, my lord. The difficulty is there. But, my lord,
at the time, my lord, the records is before lordship, my lord.
Yeah, TCR আছে দেখি
cross, PW3 deposit center.
সঞ্চর খুঁজে দাও না
PW2.
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 Eyewitnesses, PW.
PW2, my lord. Dalim Mia.
Wearing helmet also has been mentioned.
Lordship, my lord. My lord, it is not here with me, but my lord,
Yes, I have received summons. Then says I did not receive any summons to depose in this case. It is a fact that the petitioner asked me to depose the stay in connection with this case. It is fact that accident was head-on collision in between two motorcycles. The deceased wore helmet at the time of the accident. The motorcycle coming from Amjor side dashed the other. It is not possible for me to state the speed. There is a gap. The speed of the offending vehicle, the motorcycle drove by deceased Abdul Rahman, was about 30 to 35 km/h. The deceased was not my relative, but I used to meet him. I cannot recollect what color wearing. Anyway, that is the thing.
So, my lord, the entire responsibility is on the other cycle or the other motorcycle. So, my lord, on the basis of charge sheet, read with me, lord, the evidence of the.
Tell me, you are only on this ground of
Only on this
contributory.
ground, my lord, there is one small ground of consortium, my lord. This was a bachelor, my lord. The parents were the claimants. So, my lord, the consortium was granted in favor of the claimants. My lord, the total compensation as far as the general damages should have been 36,000. Taking note of 10 years, 10% increase, my lord, increase for two subsequent, my lord, periods.
42.
My lord, 30,000, 15, 15, 30, he was entitled to bachelor. He was not entitled to 40,000 consortium. 15,000 loss of estate. 15,000
No,
funeral
then why
expense.
did you say 36,000?
Minute, this 30,000 minute because it was award was passed in the year
36 or 30?
30,000 plus 6,000. That is not increase. For, 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 for 2 periods.
10% for consecutive two.
For consecutive 2 periods.
2 years. I mean,
yes, yes.
3.
3. So, minute, that is what I say, minute. He was entitled for 36,000. Claimants were
10% for each 3 years.
For each 3 years. I'm grateful.
6,000.
36. But they were granted, minute, 70,000. 70. That is at page number 34. If
Have you taken that in your grounds of appeal?
Yes, yes. Minute, kindly come to page number 34, minute. The calculation chart, C, D, and E.
Then yes, I've seen.
That is 70, 70. He was entitled, or rather, they were entitled for 36,000. Under combined head of general
Did he
damage.
file any cross appeal?
No, nothing. Entire awarded amount is secured before lordship.
Okay.
But only this amount is to be deducted. Only this amount is to be deducted from the principal compensation, my lord.
Submit one thing, my lord. My lord, the petitioner, my lord, claimant father and mother was dependent upon him, my lord. Mother already died, my lord. Before lordship, my lord, the father and the 2 brothers, my lord. Another thing is that, my lord. Yes, my lord.
It is already taken note of in the award itself.
Award. One thing is that, my lord, the father is the dependent, my lord, upon the, my lord, the son, my lord. He, my lord, after died, my lord, he, my lord, as per the, my lord, the 50% cut from his, my lord, income, my lord. It may be 1/3, my lord. My lord, as may I cite one judgment, my lord, regarding that, my lord.
Father was granted 50%, and father was granted 50% of the award. It's 50%, 18 lakh odd plus interest, my lord. And both the brothers were granted, my lord, 25%, 25% each. Mother was the lordship.
My lord, complete, my lord. My lord, I just must like, my lord, rely on these 2 judgments, my lord. Nothing else, my lord. The paragraph, my lord. Only was regarding the my lord percentage, my lord.
My lord,
27, my lord. He's a government employee, my lord. Salary slip, everything has one.
My lord, the easiest thing would have been had brothers did not want, they should have filed the wakalatnama and said we do not want. তুমি কার পক্ষে আছো বাবার পক্ষে ভাইয়ের পক্ষে নেই
তিনজনের পক্ষে
তাহলে ওদের থেকে একটা অ্যাফিডেভিট দিয়ে দিলে হতো না জজ সাহেবকে আমরা টাকা নেব না
My lord, I leave it to lordship, my lord. Actually, my child has died, my lord. My son died, my lord. I'm dependent upon my son, my lord, Abdul. My lord, my lord, one thing is that, my lord, the judgment says that, my lord, the death of the person, my lord, who is the dependent, my lord? It's a father, mother, unmarried sister. They are the dependents on the person, my lord, the victim, my lord. In this case, my lord, the father is the dependent on the victim, my lord. Just because of bachelor, my lord, 50% is deducted, my lord. If anyone was dependent on the victim, my lord, it would be, my lord, 1/3 person, my lord.
yes 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 she would have got the entire my lord before the tribunal he is happy with this award in tribunal my lord easiest thing for him would have been to file affidavit lordship
Sir, actually, 2018 Magma General Insurance. My lord, my lord, my lord, my lord, my lord. My lord, pass an order for withdrawal of 12 lakhs. My lord.
Yes.
My lord. My lord. My lord.
my lord the driver of the other vehicle was tribunal made the driver of the other vehicle responsible lordship this victim. General to make calculation, disburse to them, and then balance to be refunded back to the insurance company. Develop. Grateful to Madam.
Now 190.
This is the last
199.
The father of the deceased has come. Father of the deceased. The mother is bedridden. I think Mr. MP Chakraborty.
the tall
The tall person.
তুমি ওনাকে বলেছিলে
উনি তো আমাকে পাঠিয়েছেন। Yeah, I have already filed. Even I have filed the court number 85/25. On 21/5/25, 21st May. My court number is 85/25. Because the father of the deceased. Two. The mother of the deceased and the father of the deceased. Yeah, he generally appears.
Matters.
This company today they were not there. Huh? People.
Before my lord, I just wanted, may I mention item 102 and 103. If you will kindly recollect, my lord, this matter was remitted to the court of my lord, Learned Court, Tribunal 8 bench. For my lord, there was some my lord discrepancy in the my lord professional tax. So if you will kindly remember that 3 my lord pay slips were exhibited, exhibit 7 series. And my lord, that file has come back after addition of evidence of my lord, the income tax officer. Yes, 101, 2 and 103. If you kindly keep this matter tomorrow forward. Because returnable date is fixed today, but it could not be taken up. Pardon, madam? Yes, the matter is in that is 102 and 103. So if you kindly keeps it for orders, my lord, it is appearing, I think, my lord, as a hearing matter. So yes, everything is. Yes.
Milord, the
And learned advocate appearing for the insurance company was also. She cross-examined.
was sent back before the lordship. Upgradation. Not at least I've got to see to it. Not what is the calculation, what was the evidence? Because I do not know the records are there or not. আপনি দেখেছেন কি আছে কপি আছে এভিডেন্সের কপিটা
Certificate ko finding on matter has been sent back to this court.
maybe
At a particular date.
regular list tomorrow.
File has come back. Lord court record, everything has come back to a lordship court.
Is tomorrow.
Take a minute this matter. Yes, ma'am. I'm grateful.
কত বকা জকা যে আমি খাবো
He